Buenas and half a day. The Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research and Planning is calling this public hearing to order. It is now 9:03 a.m., Monday morning, February 20th, 2023. In compliance with open government law, notices of this morning's hearing were published in the Guam Daily Post and provided via email to senators, stakeholders, and local media, and posted to the Government of Guam Public Notices website Monday, February 13th, 2023 for the 5-day notice, and Sunday, February 18th, 2022 for the 48-hour notice, thus meeting open government law. I'd like to acknowledge my colleagues that have joined me here today, Senator Jesse Lujan and Senator Quist Duenas. The purpose of this public hearing is to discuss Bill number 35-37 COR, sponsored by Senator Sabina Flores Perez, is an act to amend Section 51111A9 of Article 1, Chapter 51, Division 2, Title 10, Guam Code Annotated, relative to updating the prohibition of open detonation and clarifying the implementation of safe alternatives for the protection of Guam's air, water, land, and the health of its people. The rules of conduct for today's public hearing. Those called to testify will be in order for those who called in advance. Also, there is a Zoom participant. For that individual, it's Attorney Thien Chow. When called to speak, please ensure that you're muted and that you're speaking into your microphone. Also, virtual backgrounds should not be utilized during this hearing, and participants' face must be visible. Individuals testifying shall be first recognized by a chair before speaking and begin by stating your name, organization, position for record-keeping purposes. Senators will also be given an opportunity at the end of each panel to ask questions. Questions and testimony shall be confined to the substance and nature of the agenda. And now to begin the agenda. Bill number 35-37 COR, sponsored by myself, Senator Sabina Flores Perez. It's an act to amend Section 51111A9 of Article 1, Chapter 51, Division 2, Title 10, Guam Code Annotated, relative to updating the prohibition of open detonation and clarifying the implementation of safe alternatives for the protection of Guam's air, land, and the health of its people. So again, the purpose of this hearing is to hear testimony on this bill, Bill 35-37, regarding developing a path forward to phasing out the outdated dirty technology of open detonation of energetic waste and phasing in the implementation of safer alternatives to open detonation. Bill 35-37 expands the exceptions for what can be openly detonated to, quote, hazardous explosive waste, unquote, in order to ensure that for those explosive wastes which lack safe alternatives, treatment, or management options, that they are treated in a manner that reduces explosive risk to the community. For this reason, primarily, it would also ensure that Guam EPA maintains its delegated authority or primary enforcement authority or primacy as a lead agency for enforcing the hazardous waste regulations in order to protect our environment. It also requires the reporting of each instance of open detonation, both through the permits granted and through the emergency procedures. The reports will be used in assessing the implementation of safer alternatives, which is the most critically needed aspect of this bill for protecting our people from the long-term effects of further contamination. Since the 1980s, the U.S. Congress prohibited open burning and open detonation of hazardous waste in the United States, except for waste explosives, which cannot safely be disposed of through other modes of treatment pursuant to 40 CFR 265.32. When U.S. EPA issued this regulation in 1980, the agency declared that the potential for human health hazards associated with the practice dictate that it be ended now. But in response to the comments from the military, the OBOD were, quote, the only alternatives for disposal of most munitions, unquote. And EPA included the limited exception to be used only during the interim status period and only for waste explosive that could not be treated with alternatives. In the 4 decades since EPA promulgated 40 CFR 265.382, there have been major advances in technologies that can replace OBOD. A 2018 study by the National Academies of Science, Engineering, and Medicine stated that there are no significant technical, safety, regulatory barriers to full-scale deployment of alternative technologies for the demilitarization of the vast majority of conventional waste munitions, bulk energetics, and associated waste. According to this report, all the alternative technologies would have lower emissions and less of an environmental and public health impact and would be monitorable and would likely be more acceptable to the public. EPA released a similar report in 2019 assessing various alternative technologies that have been used successfully in place of OBOD. And the passage of the Promise to Address Comprehensive Toxic Act, or PACT Act, that expanded health coverage to presumptive illnesses for military personnel and veterans serving overseas with exposure to open burn pits further highlighted the growing need to end these outdated, harmful practices. Furthermore, open burning, open detonation have resulted in extensive contamination and cleanup costs that reach more than $500 million at a single site. Across the U.S., the sites of open burning of hazardous waste have led to 54 separate federal Superfund declarations, including on Guam, and have exposed the people who live near them or fish near them to dangers that will persist for generations. With this long history and intense history of exposure to munitions and their contamination on Guam, at least since World War II, the passage of Public Law 36-139 received overwhelming public support with the goal of reducing toxic exposure by prohibiting open burning of hazardous waste and open detonation of hazardous waste, except for World War II ordinances until safe technology is available, with enactment date of February 27, 2023. Since the passage of Public Law 36-139, it is essential to develop the path forward to ending open burning and open detonation of energetic waste on Guam, which includes improving this law. Guam EPA is developing a compliance schedule for the implementation of safer alternatives in collaboration with the Department of Defense that is estimated to occur with potentially 1.5 to 3 years. During this interim period, open detonation may be needed to treat unexploded ordinances as well as explosive hazardous waste in cases where no alternative exists. Public Law 36-139 limited the use of open detonation to World War II unexploded ordinances, and this definition implied both Japanese and U.S. origin. And since the passage of Public Law 36-139, Joint Region has come forward with concerns that our island was exposed to more than World War II unexploded ordinances. And so Bill 35-37 expands the definition to include those potentially that are not treatable through safer management options or alternative technology, such as those from the Vietnam era and Korean War era, which according in the roundtable was brought here by the U.S. military in the staging of those wars in Asia. It has also been the opinion of Guam EPA that the recent prohibition of open detonation and hazardous waste may require an extended storage, resulting in an accumulation that could pose a safety hazard. As a result, Guam EPA's delegated enforcement authority may be impacted, and so Bill 35-37 addresses this problem in order to assure they retain primacy. To produce more transparency for our people in regards to open detonation and the contamination being released into our environment, Bill 35-37 requires that all instances of open detonation for the treatment of explosive hazardous waste are reported within 30 days of taking place to Guam EPA. And these reports will be utilized by Guam EPA to assess and gauge the implementation of safer alternatives to open detonation for the protection of Guam's air, water, land, and the health of its people, which is ultimately what Public Law 36-139 and Bill 35-37 seek to achieve. I want to thank all of those that have come here today, and so we will hear testimony from various members and stakeholders of our community. And so if I can ask both members from Guam EPA, Joint Region, as well as Pratehi, Latex, and Sabertidian, if they can come and sit at the table here, and I'll call on you. Okay, good morning. I'd like to call on first Administrator Walter Leon Guerrero for his testimony.
Good morning, Senators. Thank you for allowing us to speak. I want to start off by saying this amended bill is what is needed by Guam EPA after discussions with US EPA Region 9 to maintain our primacy. So I want to thank you for putting this effort together. I guess the original bill would have given the capabilities for the federal government to take away our hazardous waste primacy ability to run hazardous waste on Guam. So first and foremost, I do want to say thank you again. Some of the things that I do want to add that a lot of the things that are the intent of this bill are already in regulations, but they become more clear with the passing of the original law and this amendment. So again, we want to say thank you for that. Though we felt that we did have adequate authority to do the permit as we did for the last 20 years, but now there's more clarity as what's needed. And with the requirement of us putting together rules and regulations, we can actually define much better the community that we're going to be regulating. We've had past discussions with the Navy about training and whatnot, which is not part of the RCRA, I guess the federal RCRA standards as far as permitting. But so we may work that into some type of notification so that, as you put it, Madam Senator, true transparency, where everything is reported to us. I do know that almost all of these reports have gone to Office of Homeland Security and Office of Civil Defense, but it'd be good that this also allows us to get it firsthand, because we, like you indicated, we can help determine if there's alternative measures that need to be done or increased monitoring that needs to be done, which I'm not quite sure if Homeland Security and Office of Civil Defense has that ability. They probably do, but I'm not too sure. I do know where our oversight begins. The only other thing that is somewhat in a gray area that's in the amended bill is the talking about the duration of a one-year permit. I know that the initial intent was for that for emergency response, but like you've amended, notification and follow-up of a permit would be fine. But our permits are not just, they don't end just 1 year, right? Yeah. Just the duration of any permit that we provide. It's like 3 years.
I'm sorry, if you can, so Walter, you're basically, you want the more.
No, so the notification for emergency response, that's fine. We'll fine tune our comments and our written comments, but just the duration of a 1 year permit. So like our OBOD, which is what we called it in the past, and just for maintaining a continuity, our OBOD permit to Anderson, even though the OB is totally removed, that's a duration of a 3-year permit. So there's some language that we may need to change as far as just the notification of having permits for 1 year. There may be some that are lesser duration, like emergency response permit, which is a 3-month duration, versus our facility permit, which is a 3-year permit. So there are things that just that one we'll put into our written comments as far as what needs to be changed. And outside of that, ma'am, maybe just, and it's fine the way it's written, but just want to put clarity that Guam EPA nor this US EPA provide the type of alternative energy or alternative technology that is required. We will review what is submitted by the grantee or the applicant, and we will tell them whether it's feasible or not. Just to make it a clearer understanding, Guam, nor the federal government that oversees these permit applications and approves it, we don't want to take the full brunt of being responsible if that technology fails. So if we were the ones to predetermine this is a technology, alternative technology that is preferred, and it doesn't work, then that makes Guam EPA the one that's liable for all responsible or unfinished treatment. So that's why we leave it in the hands of the permittee to provide what type of alternative technology, and from there we will review and approve. Outside of that, ma'am, I'd like to turn it to Don just to make sure if that's okay with you, just to follow up on any other specifics on that Guam EPA may have. That's
Okay.
a request, sir.
Yes, so before we hand it over, I just want to make it clear that the bill does not require emergency permits. So what the bill says is all ODs under a permit shall be reported to Guam EPA within 30 calendar days. It's not about the permitting, it's about the reporting. So maybe perhaps we can clarify the language to make sure that that is not, misconstrued. Okay. So maybe, yes, so if you would like supplemental testimony, Don Kanata, I think the administrator is seeking your input in regard for supplementing his testimony. So you're recognized if you would like to say. Please state your name.
Don Kanata with Guam EPA. I guess what I can add is with regards to the permitting, if it's a treatment storage disposal facility, which is what Anderson has, their duration is for 3 years. Now, as far as open detonation, normally it's through an emergency response, which by the regulations of RCRA, it's only valid for 90 days.
Does that conclude your supplemental testimony?
Yes.
Okay, thank you. Yeah, just again, to reiterate, the bill is not about the permitting. It's more centric on US EPA, Guam EPA, making those determinations regarding the permitting. So the bill basically refocused, instead of the permitting process, it's more giving more flexibility to the agencies to do that. So there's no limitation on its permitting, I believe. So I appreciate the...
Okay, so I'm just hoping I got this, and this is where I took the 1 year. It says, Guam EPA shall require a protective permit for the OD and shall develop permitting rules and regulations promulgated through the administrative adjutant law found in Chapter 9 of Title 5 Guam Code Annotated. Permits for OD shall be valid for no more than 1 year. And that's the one that we're a little bit concerned on, because generally our 5-year permits for, again, just for the continuity's sake of our OBOD, is a 3-year time period. So it's a minor fix, but we will submit it in our written testimony. But yeah, it's just the duration of a permit. We generally have it for the facility for 3 years, and this one just restricts it to a year. Okay. And because it's a large permit and over-encompassing and a lot of things that need to be reviewed, that's why we generally go with a 3-year time period. Thank you.
All right, thank you, Administrator. So now I'd like to recognize Rear Admiral Benjamin Nicholson for his testimony. Thank you for being here.
Hafa and good morning. Chair Perez, members of the committee, and senators of the 37th Guam Legislature. I am Rear Admiral Benjamin Nicholson, Commander of Joint Region Marianas. With me today are various staff and subject matter experts on the topic of hazardous waste explosives. I appreciate the opportunity to engage on this important issue and provide testimony on the treatment of hazardous waste explosives under Guam law. We have one purpose here today: safety. This is strictly a matter of Department of Defense mission and our requirements and commitment to fulfill this mission. This is a matter of ensuring public safety. We made a commitment to the government of Guam and to the people of Guam to render safe unexploded ordnance no matter where it resides, on land, in the water, on our installations, and in the community. Public Law 36-139, and to a large extent the proposed amendments in Bill 35-37, impede upon and restrict our ability to provide emergency response without putting the safety of our bomb disposal technicians and the surrounding communities at risk. I understand the focus of this hearing is on proposed Bill 35-37, which amends the Guam Solid Waste Management and Litter Control Act, which was also recently updated through Guam Public Law 36-139. The Department of Defense uses open burn, OB, and open detonation, OD, to safely destroy explosive materials for which there is no viable alternative treatment technology. Open burn is used for bulk propellants, and open detonation is used for military munitions. Since the 1980s, federal hazardous waste regulations have prohibited open burn, open detonation of hazardous waste except for waste explosives. The Department of Defense operates approximately 35 open burn, open detonation, or OBOD treatment facilities in the United States, including one here in Guam. These facilities operate under a hazardous waste treatment permit issued by federal or state/territorial environmental regulators, such as the Guam Environmental Protection Agency. These permits allow the regulations promulgated in the Resource Conservation and Recovery Act, or RCRA, and include extensive conditions on limitations as to what can be treated, the rate of treatment, time of day requirements, weather restrictions, and monitoring requirements. In order for a facility to receive a RCRA permit, the operation must be shown to be protective of human health and the environment, and this is a statutory requirement. The Air Force operates the only permitted open burn, open detonation site on Guam. An open burn, open detonation renewal application was submitted to Guam EPA on 26 May 2021. Operations have been allowed to continue pending Guam EPA's final decision on the renewal application. In June 2022, U.S. EPA issued a policy memorandum to provide assistance to RCRA authorized states and territorial governments in the implementation of open burn, open detonation permit conditions and evaluations of whether safe alternative technologies are available. U.S. EPA is also initiating a rulemaking process to clarify how a permittee must make a determination that the waste explosives cannot be safely disposed of through other means of treatment. The federal regulation of open burn, open detonation is complex, and any unilateral changes at a state or territorial level can affect that state or territorial government's ability to enforce hazardous waste regulations. At last week's legislative roundtable on this subject, I was asked if I had previously shared my concerns about Guam Bill 360-36, which has now become law. As I will explain, I have shared my concerns many times. After a review of the original proposed bill on December 1st, 2022, I wrote to Senator Perez copying all senators of the 36th legislature, the governor of Guam, Guam Fire Department chief, and Guam EPA administrator. Unfortunately, many members of the 36th legislature reported later they did not see this letter. This first letter was submitted during the public comment period. With only a short time from receiving the draft legislation until the comment period closed, my team and I could only make a cursory review of the bill. There was simply not enough time to do a full technical and legal analysis. As such, my letter only concentrated on the two most glaring issues with the legislation. One, the bill potentially prohibiting our ability to provide support to the community for unexploded ordnance disposal. I highlighted World War II munitions as an example, but did not state this was all inclusive of the unexploded ordnance, or UXO, we encounter on Guam. Two, the bill's unconstitutional regulation of interstate commerce of hazardous waste. Additionally, in the letter, I stated, and I quote, "If invited, DoD munitions experts and I are available to discuss and share additional information about authorized, ongoing OBOD operations under local and federal law with members of the Guam legislature. I hope you will avail the 36th legislature of this opportunity to fully understand the implications of Bill 360-36 will have on DoD's national security activities, operations, and emergency response capabilities on Guam before taking action on this legislation." End quote. Unfortunately, I was not asked to address the legislature. Only a few hours prior to the vote on the bill 360-36, my team received a copy of the amended bill, which removed the regulation of interstate commerce and allowed only open detonation of World War II explosive or unexploded ordnance. Seeing issues with this revised bill, specifically the limitation to only World War II unexploded ordnance, I began reaching out to senators of the 36th legislature. Unfortunately, given the limited time, I was only able to contact two senators, one of which was actually on his way to the vote. I did not ask these senators to vote against the legislation. I only explained the issues with the bill as written. When the vote was held, the two senators I was able to reach out to were the only two to vote against the measure. After passage of the bill, I wrote to Governor Leon Guerrero on December 21st, 2022, to raise awareness of the anticipated consequences of Bill 360-36. Again, I copied members of the 36th legislature, Guam Fire Department chief, Guam EPA administrator, and also the Guam Homeland Security advisor. Having more time to analyze Bill 360-36, in this letter I highlighted multiple issues, and I closed with, I quote, "The issues above are not all-inclusive. Therefore, a full analysis should be undertaken. I am in no way attempting to thwart the legislator from enacting laws for the betterment of Guam. On the contrary, I offer to assist in the analysis of the language in the bill. Once again, if invited, munitions experts and I are available to discuss and share additional information about ongoing OBOD operations as permitted or authorized under local and federal law with members of the Guam legislature. I am also available to discuss this with you at a matter with you. After the bill was allowed to lapse into law, and after over a month of working with various stakeholders in an attempt to find a viable path to implementation, I wrote to Governor Leon Guerrero on February 3rd, 2023. In this letter, I copied members of the 37th Guam legislature, Guam Fire Department Chief, Guam EPA Administrator, Guam Homeland Security Advisor, and also the Guam Attorney General, Guam Police Department Chief, and the 36th Wing Commander. Among other details regarding Public Law 36-139 in this letter, I stated, the current language in the bill will hinder emergency response for both unexploded ordnance, UXO, and other energetics on Guam, if not repealed prior to the effective date of February 27, 2023. I have enclosed these letters as part of my testimony here today, and we have copies for them as well. Our immediate concern is the February 27th deadline imposed by Public Law 36-139. This is a mere 7 days away. This timeline does not allow for a full discussion of implementation issues, effects, or options to address significant concerns with all stakeholders. Because of this uncertainty and imminent deadline, and given the requirements in the law for regulations and permits, it does not appear that the Department of Defense can continue to provide emergency response requested by the government of Guam after February 27th, given the regulatory and permitting requirements contained therein. In the interest of promoting and ensuring safety and the protection of the Guam community, I respectfully recommend repeal of the current prohibition of open detonation activities to treat hazardous waste explosives as set forth in paragraph A9 of section 51111 of Article 1, Chapter 51, Title 10 of the Guam Code annotated as amended by Public Law 36-139. Repealing the prohibition on open detonation will give stakeholders the time to necessarily confer, distinguish the different munition scenarios implicated, and arrive at a solution that ensures safety and protection of the Guam community, without the need to rush to meet the deadline for February 27th. Although we are concerned with the effect Public Law 36-139, I will focus my comments on Bill 35-37. While some of our concerns with the current Guam open detonation law are addressed with Bill 35-37, we still have significant remaining concerns. Specifically, the Department of Defense has 3 concerns. 1, concerns requiring permits for emergency response. 2, concerns regarding extending permitting and alternative technology requirements to fired and used munitions. And 3, concerns removing the important role of a qualified explosive safety expert in assessing the viability of alternative treatment. We believe these factors put lives and property at risk. First, Bill 35-37 requires permitting for emergency response to fired munitions. Under federal law, emergency response is outside of the Environmental Hazardous Waste Permitting Authority. Emergency response is excluded from these permitting requirements as fired and used munitions that are found in the ground are inherently unsafe. Placing any permitting requirements on emergency response will delay the needed response and increase the probability for explosive incidents and harm to people or property. As all states authorized to run their own hazardous waste programs follow the federal regulations and do not require permits for emergency response. Bill 35-37 is different in that it specifically says the Guam EPA shall require a permit for OD and requires reporting on why OD is permissible under the terms of the OD permit. Since Bill 35-37 does not exempt or exclude emergency response from a permit requirement and specifically states Guam EPA shall require a permit for open detonation, it therefore requires emergency response operations to obtain a permit. This would impact all open detonation emergency responses on Guam, including those under the mutual aid agreement with the government of Guam. Put simply, the law as amended by Bill 35-37 requires the bomb squad to file a permit before responding to a bomb. We don't make the fire department file a permit before responding to a fire. First responders respond to emergencies. For the safety of life, we should not slow down their response. It should also be noted that the Department of Defense would not anticipate being the permittee for open detonation undertaken under a mutual aid agreement, as the munitions in question may not be owned by the Department of Defense or on Department of Defense property. Second, Bill 35-37 presumes that all explosive waste is the same with respect to identifying alternative treatment technology. However, alternative technology evaluations are not appropriate for fired or used munitions. These munitions, known as unexploded ordnance or UXO, are inherently unstable and have been degraded by exposure to the environment over time. Handling and transport of these items must be minimized to avoid unacceptable explosive safety risks. According to the report, Alternative for the Demilitarization of Conventional Munitions by the National Academies of Science, Engineering, and Medicine, which you quoted earlier, I quote, "Some munitions have been determined to be unstable and possibly shock sensitive owing to depletion of stabilizers in the explosives or propellants caused by excessive age. This makes them unsuitable of demilitarization using alternative technologies because transport and handling must be minimized to reduce exposure to personnel to the explosive hazards posed by these munitions that may detonate or deflagrate when disturbed." End quote. Furthermore, when a munition is unearthed, it may begin to decompose faster. It is now exposed to the air, and oxidation or rust of the components can accelerate. Therefore, stockpiling of a UXO is unsafe. Additionally, emergency response occurs for a multitude of different items, such as improvised explosive devices and fired war munitions that make alternative technology evaluations impractical. However, Bill 35-37 only allows open detonation for hazardous waste explosives for which, quote, Guam EPA and US EPA have determined that no safe alternative management options exist, end quote. Since nothing in Bill 35-37 exempts emergency response from alternative technology evaluation or clarifies that this evaluation is limited to unused munition, open detonation, emergency response is therefore also prohibited unless or until Guam EPA and US EPA determine that all emergency responses have no safe alternative management option. Other states which have the US EPA-approved hazardous waste programs have adopted current federal regulations that do not require alternative technology evaluations for fired munitions. That is emergency response, and instead apply only to unused waste explosives sent to a hazardous waste permitted site. Current US EPA guidance on the requirement for alternative technology evaluations are for hazardous waste permitted open burn, open detonation sites, which treat regularly generated, well-characterized, unused waste explosives. These sites do not treat fired and used munitions as part of their permitted activities. Consistent with the federal regulations, the hazardous waste permit renewal process is the best place to make this determination, not annually as required by Bill 35-37. The Department of Defense supports alternative technology evaluations for permitted open burn, open detonation facilities and has also significantly reduced the number of facilities in the last 2 decades. As stated earlier, the Air Force operates the only permitted open burn, open detonation site on Guam. The Air Force has committed to working with Guam and US EPA to evaluate the viability of alternative technologies for open detonation of munitions waste treated at Andersen Air Force Base during the current permit renewal. I have enclosed the June 17, 2022 Air Force letter to Guam EPA on this issue as part of my testimony here today, and that's part of the copies provided. Third, explosives or munitions emergency response specialists must make determination whether an emergency exists. They are the only persons qualified to make the final determinations from an explosive safety perspective of what alternative technologies to open detonation are suitable for each specific military munition designated for permitted hazardous waste treatment. On Guam, only the Department of Defense has this experience. The Department of Defense requests, the Department of Defense respects the important role of US and Guam EPA in making a determination if there are viable alternatives to open detonation. However, the most important factor in this decision-making process is safety to human life. Because of the pending February 27th deadline, we believe the best way to proceed is to repeal the open detonation portion of Public Law 36-139 as an interim step, then continue to work with all stakeholders to determine what legislative or administrative changes are needed in concert with US EPA existing regulation and future rulemaking. However, if the legislature elects not to repeal the law, I recommend adoption of an amendment to address 5 issues of concern. 1, allow for continued use of open detonation for unused hazardous waste explosives at the one permitted site in Guam, and require an alternative technology assessment in conjunction with permit renewals. 2, allow for open detonation of emergency and munitions response to continue without permitting and alternative technology requirements, but require reporting within 30 days after open detonation. 3, allow Guam EPA 3 years to promulgate permitting regulations with a provision that Guam EPA shall follow U.S. EPA regulations in the interim. 4, provide that any new law becomes effective 180 days after Guam EPA promulgates implementing regulations, which should allow adequate time for owners and operators to apply for and receive permits without gaps in coverage. 5, require Guam EPA to adopt the Military Munitions Rule, MMR, as have 87% of the other states and territories that also regulates hazardous waste. Unfortunately, there are only 7 days remaining before the current law goes into effect, and at which time the Department of Defense can no longer provide emergency response to the community. I am concerned this is not enough time to collaboratively conduct a full technical and legal analysis of these amendment recommendations. Therefore, I continue to recommend repeal of the open detonation portion of Public Law 36-139 as an interim step while we collaboratively work with all stakeholders on a mutually agreeable solution which puts public safety first. We sincerely appreciate the opportunity to provide our perspective. We welcome further collaboration on this complex issue, and if requested, we would be happy to provide technical assistance. Suzus Masi, and thank you.
All right, thank you, Rear Admiral. I'd just like to recognize my colleagues that have joined me, Senator Joanne Brown, Senator Tello Taitigui, Senator Tom Fisher, and Senator Chris Barnett. Okay, so a couple of things. So it seems like the wording is what's posing more of the problem than really the bill itself, because I think there's some things here that can be amended without the full repeal as you recommend. So I guess the question I have, so the 5 recommendations that you have, first of all, can we get a copy for all the senators to look at your testimony?
I will provide a copy after. Yes, ma'am. I don't have copies for everyone right now.
Yeah, my staff is ready to make copies if you're willing to do that. Yeah.
They'll make copies now.
Thank you.
I apologize. It's written in very large font, so I could read it without my reading glasses.
All right, so in the 5 recommendations, I mean, we can work fast here as far as making sure that the safety risk is a concern, right? And this is something that I take seriously, that I would like to, expedite any kind of changes to the bill that would address the concerns that you have, as well as to ensure, the safety of the environment. Yeah, really, can you just, if we were to address those 5 recommendations, is that sufficient? If we were to make those changes in the bill, would that be sufficient to address the safety risk? I think, first of all, the bill itself, again, it moves away from the permitting. So unless we can come up with a language that really satisfies the concerns, I feel that with the way the bill is written, it allowed EPA the flexibility, and it doesn't touch the emergency permitting. What it addresses is the typical permitting process, not the emergency. The emergency is untouched in the bill.
And ma'am, I understand the intent, but that was the problem that we have. Because of the way the language in the bill is, that intent does not come across clearly. And so it takes time to analyze these bills from a legal and technical perspective. And so we have spent a significant amount of time, not only with the staff here locally, but with DOD lawyers in Washington, D.C. that have looked through the bill, and that's why we had those recommendations. So going back to my earlier comment, the reason I don't think that the 7 days is enough, even if we were to implement those things, I think the best thing to do is to take our time to review thoroughly and have a full technical and legal review of any bill amendments that are changed. Rushing in to change something, although we think we might meet all of the parts and pieces, I'm concerned there might be something that we left out, and that's why I would like to take more time. That's my recommendation, was to repeal just the open detonation portion of the bill, not the entire bill, just the open detonation portion of the bill, so then we can have the time, so amended language could then be looked at, analyzed, and all parties could say, yeah, this works. There's no other things in there that we missed the first time, like has happened subsequent in previous times.
Okay, so again, the bill does not touch the permitting. It's really just about the reporting of the emergency. And so I have been in communication with US EPA, and they're amenable to the bill with some changes.
Right, but
Yeah.
what I'm saying is the bill as it is, because it does not specifically exclude, the way it's written, the lawyers, the Department of Defense lawyers, they look at this and they say, hey, you can't have your DOD personnel do this. It says the Guam EPA shall require a protective permit for OD and shall be valid for no more than 1 year. All ODs under a permit shall be reported to Guam EPA within 30 calendar days of each year. But it does not specifically exclude emergency response. That's the problem, is that even if the EPA lawyers say, hey, this is good to go, the lawyers that govern how we conduct business say that is not good to go. It does not specifically exclude these things, and that puts us in a problem. I cannot order my people to do something that's illegal. And so we have to be extremely clear on the language to make sure that I am not issuing an illegal order and having them do something that's illegal. So I understand the intent, yes ma'am, absolutely. However, there's wording there that needs to be, it has to be understood by all attorneys on all sides. And so that's why, again, I'm concerned that we don't have enough time to put the things in and then have a thorough legal review before it goes into effect. That's where I'm coming from, ma'am.
And so in the roundtable, you mentioned that you're committed to the open burn prohibition, right?
We have no problem with the open burn prohibition. It's the open detonation and portion that we're concerned with.
Okay. So we'll have more follow-up questions from the panel here, from my colleagues. I'd like to open the floor now to Monica Flores from Patela, Texas.
Manegaf Ogan Hafide. Good morning, Senators. Thank you all so much again for the opportunity to provide testimony today on Bill 35-37. Here with me today, again, my name is Monica Flores. I'm a core member of Protehila Texan Savertidian, and joining me today are two of our attorneys. We have calling in from Zoom, via Zoom, attorney Tien Chow with Earth Justice. Earth Justice is a nonprofit environmental law firm that's doing incredible work across states and territories to fight climate justice issues and environmental justice issues. And also with me today is our attorney Rachel Taimanyawa Duzu. And just really grateful that they could also be here to provide testimony. Patela Texan is very interested and invested. A lot of you know now that we are committed to protecting and addressing several tremendous risks, all of these risks that come with the construction of the live fire training range complex, the construction of the new Marine base, and of course with open burn and open detonation. And it's important that we frame all of these things in a larger context of a very long history now of environmental injustice issues and environmental racism. We have to measure it against, all of the risks that are coming. And the fact that we were here last week at a roundtable and we heard from the Department of Defense that they have no idea, absolutely no idea, after 75 years from World War II, after 70 years from the Korean War, after 45 years from the Vietnam War, they have no idea how many of those munitions remain here. And it's important to reiterate that that risk was brought here by the Department of Defense, and that now new threats are coming. And so we're very grateful for this bill and any legislation that tries to prevent further harm from happening, that tries to protect our cultural and environmental resources. You know, we are concerned about the protection of our aquifer. Open detonation has absolutely no controls for air emissions. And open detonations are happening right now under the previous permit. We've received several videos. We've taken some videos of ourselves of open detonations happening on Taragi Beach, and we've seen that the air travels all over the place. It goes to two of our most concentrated villages, Jigo and Dedido, and a lot of these chemicals, you know, they build up in concentration over time. They build up in concentration in our bodies. We're not talking about a one-time exposure. We're talking about a lifetime of exposure to toxic, hazardous waste. Okay, and open burning and open detonation means that these chemicals travel freely. They go into the soil, they go into the groundwater, they travel through the groundwater. And, you know, when I say we have to paint it against this history, we're talking about we already have 100 military toxic sites, 19 Superfund sites, many generations suffering from cancers and other illnesses, from radiation exposure, Agent Orange exposure, PCBs. Just a couple years ago, 500 tons of contaminated soil from a jet fuel leak was destroyed. And also, not to mention that every single water well that's been returned to the government of Guam from the military water system has PFAS and PFAS contamination in it. And that is very serious. With the new firing range, we're going to see the use of open detonation for new, stronger kinds of explosives with chemicals that make these things sturdier, that will bring more contamination. And so, again, Senator, thank you so much for introducing this bill, for the needed changes to keep our community safe. We do recognize that unexploded ordnance is a serious issue here. Like was mentioned last week, we have no idea how much unexploded ordnance remains in our island. And so, thank you, and we encourage all the senators to, you know, try to move quickly to pass the necessary changes. A lot of you know that we are involved in a lawsuit against the Air Force for violation of the National Environmental Policy Act in their permit renewal application to conduct open detonation and open burning. And, you know, we believe that they violated that law, you know, in various ways. With that, I think I'd like to turn it over to our attorney, Tian. But just to mention, you know, just some of the chemicals that will come about in these practices of open detonation: RDX, lead, TNT, perchlorates, PFOS, and PFAS. Okay, these are forever chemicals that don't break down in the natural environment. They build up and cause a lot of illness. And so, yes. I'm going to go ahead and turn it over to our attorney, Tian Chow, and we're also going to be submitting a lot of supplemental written testimony as well. So if I could turn it over to Tian. Thank you, Tian, for joining us.
Right.
Good day and good morning. Thank you. Oh,
Yeah, Attorney Chow, you're recognized. Thank you. Please state your name.
thank you. Good morning. My name is Tian Chow. I'm an attorney with Earth Justice, presenting testimony today on behalf of Protégez le Texan, urging the passage of Bill 3537. Before I start, I want to thank you, Senator Perez, and the rest of the committee and the Guam legislature for the opportunity to speak today on this bill. This bill intends to ensure protection of human health and the environment from the inherent dangers associated with open detonation, while also maintaining the capability of emergency responders to address munitions and explosives emergencies. It is also consistent with federal law and policy on hazardous waste management and will not threaten Guam's primacy over its hazardous waste management program. Given some of the statements that have been floated regarding this bill, including at Thursday's roundtable and at today's hearing, we need to be clear on what this bill will and will not do. This bill prohibits the use of open detonation when there are safe alternative management options. Alternatives include alternative treatment technology, safe storage, or safe transport to a facility with an alternative technology for treatment. Bill 3537 will not prohibit emergency responders from using open detonation in the narrow circumstances where it's necessary. It only requires that safe alternatives actually be considered, and when a safe alternative management option is available, that it be used in lieu of open detonation. Bill 3537 will not require EOD text to determine whether the munition is from World War II, avoiding the concerns that JRM raised about the previous public law related to Public Law 36139 regarding safety issues in making that type of determination. Bill 3537 will not put Guam EPA in the role of an emergency response technician. Guam EPA will retain its crucial role as a regulator and develop rules and procedures that emergency response teams will follow, just like any other standard operating procedure and environmental regulation that emergency response teams currently are required to follow. If Bill 3537 is passed, Guam EPA will be able to work with US EPA, the public, and the military to develop regulations and procedures to facilitate emergency responses that are safe for the EOD team and protective of human health and the environment. This is an important aspect of the bill that we need to emphasize. The part clarifying that Guam EPA's role is as a regulator that must approve or deny the use of open detonation. Of course, Guam EPA can consult with the military and benefit from their experience and expertise in dealing with explosives and munitions emergencies. They can also rely on the expertise of US EPA. Seems that Guam EPA has been in constant communication with US EPA Region 9, for example. And they can use this expertise to determine when alternatives to open detonation are available. But regulations, hazardous waste regulations, including the ones under the Resource Conservation and Recovery Act, exist for a reason. And it'd be inconsistent with the idea of having a hazardous waste regulatory regime just to then leave actors to their own devices, devoid of any accountability. We don't need to look any further than at what happened with the Andersen Air Force Base permit. Andersen didn't look at alternatives as it was required to by existing law, and instead made conclusory statements that no alternatives to OBOD were available. At the roundtable hearing on Thursday, the Guam EPA administrator said there are in fact 2 to 3 alternatives that are available. And this application was submitted nearly 2 years ago. So if Andersen, for example, had complied with the law at the time, we might already have alternatives installed and operational by now and avoid ongoing open detonations that threaten human health and the environment. So it's clear that Guam EPA has a critical role here to ensure compliance with laws meant to protect communities and the environment. And that's exactly what Bill 3537 does by clarifying that Guam EPA, in consultation with US EPA, has a role in approving the use of open detonation. And I want to emphasize that point. Under existing law already, facilities requesting authorization to use open detonation are the ones that have the obligation to do the alternatives assessment. And as Guam EPA testified today, it's up to Guam EPA and US EPA in certain instances to then examine whether the assessment was done and done in a way that satisfies legal requirements. That's exactly what Bill 3537 does. It clarifies that requirement to ensure that we have compliance with law in Guam. Excuse me. Now, in response to some other concerns raised today about primacy, the Guam EPA administrator himself said that in consultation with US EPA, it appears that Bill 3537 it will not threaten Guam's primacy at all. However, I want to clarify a couple things that were mentioned by the Guam EPA administrator as well. Bill 3537 does not change the fact that emergency permits cannot be issued for more than 90 days. It's entirely consistent with that federal requirement. Bill 3537 only provides that OD permits be for no more than 1 year. So for emergency permits, they can still be for 90 days or less. Further, although Guam EPA currently provides a 3-year duration for OD permits, a 1-year duration for OD permits would be consistent with federal law and even more protective because it would ensure the periodic reevaluation of alternative technologies that EPA in its June 2022 memo clarified is existing requirement under federal law. Additionally, I want to discuss some points raised by the Rear Admiral about safety issues. As I mentioned already, under this bill, where open detonation is absolutely necessary, it'll be allowed. There's nothing in this bill that's going to stop emergency responders from using it. It just seeks to ensure that it's only used when it's absolutely necessary, given the serious and inherent dangers associated with open detonation. Emergency permitting already exists under federal law as well, under 40 CFR 270.61 for certain situations involving hazardous waste emergencies, which also include explosive hazardous waste. There's no reason for Guam to not pass Bill 3537 to ensure that alternatives are being assessed for these emergency situations. Bill 3537 doesn't say that the assessment has to be done in each individual instance when a munition is found. This can be done ahead of time in the annual permitting with conditions worked out for munitions that haven't been assessed yet and for which there's no time to do so when responding to an immediate emergency. Well, what we can't have is a blanket authorization to do open detonation without taking into consideration any alternatives at all. We also don't dispute that the National Academies of Sciences acknowledge that there may be some munitions for which open detonation is the only available alternative. But again, the point is that we just can't have someone make this blanket statement and not having actually done the assessment with an opportunity for Guam EPA as the regulator, along with US EPA and the public to provide input and oversight. This is why we believe the permitting requirements of Bill 3537 are important as well, because as I mentioned, it provides a mechanism to ensure the annual periodic reevaluation of alternatives, and it allows that evaluation to be done ahead of time. And it also gives the public an opportunity to be involved in this process to ensure that there's transparency and accountability. And finally, regarding the timing of everything, at our Thursday roundtable, Guam EPA said that they can do the regulations in 120 days. And Bill 3537 provides that in the meantime, existing federal regulations can apply. So there really is no emergency in the coming days for the Department of Defense to be able to respond to emergencies as they arise. And in those 120 days, the Department of Defense, UPA or US EPA, and the public can work with Guam EPA to modify the existing regs and ensure that all these issues are being addressed, although we believe that 3537 already addresses all these issues. And to the Rear Admiral's point that this is a thing that could wait 3+ years, that's not that. If you just listen to the people who are expressing their concerns about this now, the people in Guam, our client, PROHIBITION, Texan, 3+ years is too much. They've already waited plenty of years. As I mentioned, the Anderson Air Force Base permit, for example, was submitted 2 years ago, and it was unlawful, and yet open detonations continue to happen under that permit. So to ask them to wait for another 3 years is simply unacceptable. So thank you, Senator Perez, and to the committee for this opportunity to present my testimony.
All right, thank you, Attorney Chow. I guess I have a couple questions. So, there seems to be two different responses happening here, and I imagine it's probably the way the wording of the bill. So maybe you can bring some clarity to the part. So there seems to be interpretation that this bill would prevent emergency response, but the bill does not. And I just want to find out what the source of that, what wording in this bill is I guess, what's maybe that's being interpreted as such. I mean, I feel like there's wording that we can clarify so that it is clear that it is not affecting emergency response. Is there additional language that we can, you would suggest, or maybe perhaps in your testimony, written testimony, you can provide that more clear language? So I guess maybe this would go for, this is a question for everybody, but maybe we can start with the, Attorney Chow, if you can think of any of the wording in the bill to make it clear that it is not it's not affecting the emergency response.
Yes, thank you, Senator Perez. I think the main part of the bill, in the very beginning, it says that use of open detonation, so it prohibits use of open detonation to treat explosive hazardous waste, except for those hazardous waste explosives for which Guam EPA and US EPA have determined that no safe alternative management options, including treatment or disposal technologies, safe storage or transport, exist. I think that's a very clear exception and consistent with the federal rule, providing for the use of OD when it's absolutely necessary. So in these emergency situations, if it's actually shown and determined that OD is the only safe method of managing this hazardous waste, then it wouldn't impact the ability to use OD to address those emergencies in that instance. And to the Rear Admiral's point, again, if there is a concern about requiring an EOD tech to make these determinations or to work with Guam EPA to make these determinations in that instance, and that delay would cause too much time, well, as I offered earlier, there's an annual permitting regime for open detonation, and in that process, or in the rules and regulations process, these situations can be addressed to make sure that there isn't any sort of delay that causes a safety risk.
So that question too would go for the Rear Admiral. So you've heard the testimony from Attorney Chow. So what particular language would you recommend as far as changing it so to be assured that it's not affecting? Is it the word exist? Is that the word?
Ma'am, this proves my point in that you have multiple different lawyers looking at this from different angles, and this is why I'm concerned on the timepiece here. But setting that aside, we previously provided a technical drafting assistance document to the governor at her request that goes through the bill and shows exactly where the language needs to be changed. For example, in Section 51111, prohibited hazardous waste activities, number 9, use open detonation OD to treat unused hazardous waste. So there's a number of technical details that could be worked out to actually make this thing workable. I'm just not sure there's enough time to do that in the time frame allotted. I mean, and if we want to go through in this session and try to go through all of those changes, we can. But that's quite a bit of work that I think should be, in my opinion, we have the attorneys do offline, and they work that out so that both sides clearly understand. Because as stated earlier, both yourself and the lawyer from Earth Justice believe the law does, or believe the bill does something, but our attorneys believe the bill does something else. That has to be resolved to ensure that we can do these things, because that's what I'm concerned about. So that's just one example there, is it doesn't specify what the prohibited waste activities are, vice the ones that are permitted. So that's one example of several again, in the technical drafting document that at the governor's request we provided that kind of went through that law. But that's the work that needs to take place, ma'am.
Is this something you're willing to share with the committee as far as
Absolutely.
the technical doc? Okay, thank you. So the other thing is, perhaps we can put language in there saying an exemption for emergency response. Would that suffice?
Ma'am, we're gonna make copies of the technical drafting assistance document that we did and provide it to the committee as well. Sorry.
Yeah, I mean, that's something we could put in the bill, is basically we're exempting emergency response to make it absolutely clear that, we're not
Clarity would be
affecting.
appreciated.
Okay. Yeah, and just to kind of make it clear too, the munitions rule, right? It states that for instance, ordinances are not necessarily waste until it's deemed not useful, right? So we can't just put a blanket exemption for ordinances in case they are repurposed. And so that's why I think, I agree with you, the munitions rule has to be adopted. But as far as, the language in the bill, that's why explosive hazardous waste, the language is there.
Ma'am, I would say if the military munitions rule were adopted, we wouldn't be here today. It really does take care of most of this. The regulations that enforce this, in fact, what it causes the department to have to do with regard to inventory management, all this kind of stuff, I think it would have really taken care of this a long time ago, and it's actually been out there for quite some time.
Yeah, but I just want to make the clarification that the change in the bill in regards to explosive hazardous waste, it takes into account the munitions rule, because just because something is a munition doesn't mean it's waste until it's no longer useful.
Correct.
Yeah, so that's why this change, I think that was one of the big changes from the public law, is that we recognize that an ordinance can still be useful and is not waste, right? So, and it does kind of open it up to the other emergency things that we need to respond to as well. So that's one of the big changes that this bill does.
Ma'am, just for our purposes, a munition is no longer useful when it has become expired. It's not repurposed on site. That's things that happen at a depot at a different place. So that's why the MMR, I think, is an important adoption. But I do understand your point.
Yeah, and then the other thing, so the difference about the MMR and this bill is that this bill takes into account the report that the National Academy of Sciences, Engineering, Medicine came out. So the rule came way before that report. And so what this bill is more of a modernization of how we deal with with explosive waste and how we need to limit, in light of this. And I think there is a move, obviously, to address that with the new technology, that there has to be some way to integrate these newer options, right? Not necessarily the technologies, but also the management options. So we need to keep a broader perspective when it comes to this. So waste management should be on the top of the list, right? Prevention is probably the best thing. Can safer storage, I mean, we heard from in the roundtable, there's a limit to that statutorily, 1 year. Granted that there are safe places to store them. Safe transport, so that's something that could be evaluated. OD should be the last thing, right, on this list of what can, how to handle explosive energetic waste, right? And so that's really the intent of this bill, is to integrate not only these older the munitions rule, but also to see how we can phase out OD. And I thank you that you're in agreement with banning open burning, but I think we need to also work together to phase in, phasing out. Sorry, we have to work together to phase out the open detonation part, because a lot of these weapons that were left behind are of great magnitude and have a capacity to, harm the community both inside the fence and outside the fence. And so, that's why we're here. And we're here because, the safety issues that you pose, and we're willing to work very expeditiously to address that before the deadline. Anything, I appreciate your feedback, your technical notes, and we're going to work hard to get this amended so that, the spirit of phasing out OD, but at the same time balancing the explosive risks for all of these things that were left behind. So
Ma'am, if the
I appreciate your
MMR had
presence
been
here.
adopted, the only OD that would be taking place here on Guam is emergency response.
I'm sorry.
If the MMR had been adopted previously, the only detonations taking place here would have been emergency response. We really wouldn't be dealing with anything else.
Okay, but there's other things too that are being brought in. So
The MMR, that's what I'm saying, ma'am, that the military munitions rule, as adopted by multiple other states, that would have actually, for all intents and purposes, it would have limited our open detonation only to the unexploded ordnance, or IEDs, pipe bombs that the police finds, and these sort of things that we respond to as well too. It would be very different. It's just unfortunate it was never adopted here.
okay, and so just to be very clear, the bill does also, there is going to be some time before rules and regs are promulgated. It allows for the current regulations to be in effect. So, so basically what this does, it allows for that phase-in period, if you look in Section 3 of the bill. So we can continue to rely on the current regulations until new regulations are promulgated. And so, I'm open if, we need more time for those regulations to be developed. That is something that we can amend as well in the bill to ensure that the transition happens smoothly.
And that is in our technical document that we provide.
Yeah, so, with, even with the passage of this bill, there should be no, disruption. What I see is no disruption if we're following the current regulations.
I agree if these additional changes are made.
Okay. All right. I appreciate that. Thank you. All right. So I would like to open up the floor to my colleagues in order of arrival. Senator Jesse Lujan.
Thank you, Madam Chair. Thank you, gentlemen. I'm trying to merge last week's roundtable and today's as well. And I'm a little bit confused about some of the things here. But let me first off the bat, Rear Admiral, short of repeal of the section here dealing with open detonation, short of a repeal of that, 8 days from now, you would no longer be, I guess, responding to ordinances in the community, outside of the base, maybe?
Sir, unless the current bill is repealed, or at least the open detonation portion of the bill is repealed, or the amendment is changed with specifically with the sections that we have asked to be changed, barring either one of those, yes, we stop on the 27th of February.
Okay. The other thing that came up on, I think it was Thursday that was, where Guam EPA said that 120 days is a feasible time to come up with rules and regulations.
Senator, I said that we would work our best to make that happen. As many people know, to promulgate regulations takes a while. Not only to write the draft, but having the public comment period, having all the other required permits. And if you recall, I said it's possible, because it is possible.
But highly unlikely.
I would not want to say that because I don't like to put caps on my team and have an awesome team, and I think they can do it if forced to.
No, the reason why I asked that is because the question was posed to the EOD folks in regards to how long does it take for their training, and they said about 9 or 10 months for intense training for that to happen. But not only the 9 or 10 months, but being out in the field, it takes years for them to basically be experts on the ordinances in the particular areas that happen. So the 9 or 10 months plus, again, additional, not training, but in service, out on the field type training would occur. So, I mean, have you collaborated with EOD folks in regards to really what is the feasible timeline outside of the 120? I mean, saying that it's possible, maybe highly unlikely. What is, if you were given the date, you would say, Mr. Director, I need you to put these rules and regulations together. Mm-hmm. How much time would you need, based on the staffing you have and the collaboration with the military, how much time would you need to put that together, as opposed to maybe an unexpert saying 120 days, I think you can do it in 120 days, but you have the expert working with the experts and working with the staffing that you have. What time would be a feasible time for you?
I understand your line of questioning, Senator, and I appreciate it. Answer is I couldn't say right now. We would, again, it would be in discussion with the technical experts, DOD, and any other private entity that does UXO monitoring and removal to get their part. But I think that what needs to be stated is we've been looking at how to do the regulations in a fast track, quicker mode than normal. And part of our discussion is, even if we come up with the draft regulations, our draft regulations would encompass a compliance schedule time. So if you're thinking that when we do the regulations, everything needs to be mandated by the regulations that are promulgated, no, that's not what we're looking at. We're kind of what you were saying, Senator, about having the regulated community be given the time to implement everything. We're looking at that as part of our draft regulations to have a compliance schedule. And I think Senator Perez mentioned that earlier, that it could be anywhere from a year to 3 years of compliance schedule. So putting out the draft regs is a tough cookie to swallow initially. But to actually think that the draft regulations would be implemented immediately, that's, don't mind my words, but that's crazy.
Yeah.
That's not going to happen. So that's why you would develop the compliance schedule. And the compliance schedule will allow the regulated community to get up to speed, get up to par, and be able to implement it. I mean, I know DOD, everyone thinks that they got deep pockets. We all know they got deeper pockets than most, but they don't magically get money either. So we know that as well. So they need to work on getting their budget, their things. So we've taken that into consideration. We have not written any of the draft regulations, but this has been a lot of our discussion. So again, 120 days would be really tough to come up with draft regs, but by no means would those draft regs be implemented in 180 days? Just that cannot be done.
Yeah.
So I want you to understand Guam EPA's thinking. Is it would be tough to write those draft regs in that time, especially as you mentioned, Senator. We would do that with the interaction with the stakeholders, the potential regulated community, and if you're hearing already, we have some type of not disagreement, but just maybe attorneys they want to see something written one way, and all attorneys don't always see eye to eye. So their interpretation of what needs to be written in our draft regs may not meet ours. So, those impasses that may occur could take longer than expected.
And I'm sure they will occur.
You hope they don't, but you hope that DOD loves us so much, don't say, whatever, Walter, go for it. Which I know is not going to happen. You know it's not going to happen, Senator. I mean, we can laugh about it a little bit, but, that's, again, when you ask me the duration of how long would it take, it would just, we're all on the same page or not. And I can't say that, especially when, no offense against attorneys, Senator Fisher.
Sure.
But sometimes they insist on something, and so sometimes that will be the longest delay in getting draft regs promulgated.
Sure.
Thank you.
Likewise, short of the repeal of the section here that deals with open detonation, and maybe the amendments as recommended, 8 days from now, if the Department of Defense decides, okay, well, it's not a repeal and the amendments are not made, and we will no longer respond to these emergencies as called upon them, is EPA, is anybody in EPA or is EPA of any organization at this point that will respond, that will take over the management of those calls that may happen?
Yeah, Senator, I've been at Guam EPA for almost 30 years. I've done emergency response myself. I have been offered by Army Corps to take the EOD training, and I said no, thank you, because that's not my cup of tea. As far as I know, Guam does not have any people on staff on salary. There may be retirees that had previous EOD training. I don't know of them per se. I know that there's some private companies that are looking, but even at that, the few discussions I've had since the new law came out and it's amended, they only talk about recognizing and reporting. So they're still not even talking about final disposal like the EOD teams do. I just want to restate, and I made this statement Thursday, and I'll make this statement numerous times. I've made it numerous times in the past, and I'll make it in the future. We are not in the business of doing EOD. So we do have to rely on DOD and their technical expertise on that matter. We do have a venue that we can knock on US EPA's door, but even them, they're not actual technicians that blow. They're people that are studied in it, and that's where we get some of the technical guidance on them. But again, emergency reporting and permitting, I understand where DOD stands on that. Our amendments would be, it'd be a call for notification, then that could be followed up with 30-day permitting or after the fact permits, just so that the intent of the law and having all this full disclosure not only to Homeland Security but to Guam EPA, that's an added burden, but we can easily take that on. But I think that may resolve some of that discussion that DOD says, why is EPA or even US EPA more expert than us when it comes to emergency declaration of whether they detonate in place or not. By no means were we ever looking to take over that role. Again, it would be just, our recommendation be change that to notification, and then you do an after-the-fact permit, and that way all the paperwork's in place.
That being said, Mr. Director, again, should DOD decide that this is not a task that they're no longer going to undertake, based of non-repeal of the open detonation and maybe the recommended amendments here, current construction sites that may happen upon unexploded ordinances after 8 days, would then the EPA put a halt to that construction site?
We don't have that authority. I do understand your question, Senator. Again, because we don't have the expertise to deal with unexploded ordnance, I don't have a really good answer for you at this point. If DOD removes their ability to respond, I don't know if there's anybody on Guam that would do that, take over that lead. And again, that's not Guam EPA's oversight to say, well, since there's no UXO technicians or ability to remove it, all construction needs to stop. That's not in our ability.
I guess let me rephrase it at this point. Any current construction sites that may come upon unexploited ordinances, they would call DOD to remove it.
Outside the fence, the process generally follows that they call 911. 911 would call Homeland Security, Office of Civil Defense. Generally, they would try to contact us as well. That's part of the procedure, but not necessarily what happens all the time, which is why I applaud this extra, reporting ability in the bill. Even though it should be done, it's not necessarily done. So it may be a redundant statement that I applaud, but as far as any reporting goes, it goes through 911 system, and then they call the appropriate agencies, and the appropriate safety mechanisms are taking place.
I guess my point is here is the reason why these contractors or individuals who may come upon these unexploded ordinances that they would call because they don't have the expertise on hand, and so I've gone through the permitting process as well. If I came before an unexploded ordinance in my property, I'm out of there.
Exactly,
I'm out of there. And I would self-impose a construction halt.
Right. Army Corps has a great statement on UXOs. This is 3 R's. Recognize, report, and remove yourself, basically. Yes.
See something, say something, right? Get out of there.
Stay
And that's my point. I mean,
during my course of my career, we do the 3 B's: beer, beach chair, and binoculars. Further away you are, the better you are when it comes to things like that.
And that's my point. Again, I mean, other than what we have currently in regards to the responders to these ordinances, if that again that service is no longer provided because again of non-repeal of the open detonation section here, and based on the recommendations through the amendments, EPA doesn't have the expertise. You don't know of anybody else that has the expertise at this point, and again, you don't have the authority to stop construction. But based on experience, those sites will shut down anyway because it's hazardous to everyone involved, right? Safe to say that?
That's correct, sir. And not to side with DOD or not to side with anybody. Sure. DOD, when they came up with the MMR rule, they kind of did this outline of the island, and because we were occupied and we had invasion, the Imperial Japanese forces, as well as the reinvasion of the Marines to liberate us, or DOD to liberate us, Guam at one point, and this is a DOD map, had all of Guam high risk for UXO and MMRP or MMR and MET, because again, what DOD has stated, and I agree, doing a lot of legacy cleanup on this island, we don't always know where the bombs landed.
Sure.
So
Sure.
that's a fact of life that we have to deal with.
Sure. I mean, again, as Senator Fisher had said before, I mean, there are finite numbers, but it is unknown. it is unknown at this point, and if you do have those numbers, share with us, so we would know and start chipping away at how much is left. Anyway, so one more time, Admiral, again, short of repeal of the section here of the again of the open detonation, or the amendments that you fostered here is implemented before the end of the month, before the 27th. My understanding is DOD will no longer then respond to calls for emergency munitions should they be found.
That is correct. Now, we may send someone on site to look at it and say that's a pipe and not a pipe bomb, but other than that, where, you know, if it's something that can be removed because we know that it's not ordinance, that might be the only thing that we could do. But other than that, if it's ordinance, we can't do anything about it.
Okay, thank you very much. Madam Chair.
Thank you, Senator Lohan. Admiral, I'm sorry, Administrator?
Yeah, I just want to make sure that it's understood. Guam EPA stance is not that what can or cannot be done by DOD. Again, that's thank God for me. That's your guys' job. If you guys can make an amendment in 7 or 8 days, awesome. That DOD's EOD team can do their proper response. If they can't, again, I'm not saying that there's a repeal that needs to be done. I'm saying none of that. I just I agree. If they're up, and that's their statement, and that's really what they're going to do, I hope that this body finds a way to do it, whether it's to make an amendment in 7 days, that they are comfortable to do a response. But I just want to make sure that we don't confuse Guam EPA stance.
In other words, you're saying you're relying on their expertise.
That's right. That's correct.
Thank you, Madam Chair.
Okay, just a clarification, because the current law allows for World War II detonations. So you're saying that you're not going to engage in that activity, just even, I mean, the safety for the public?
You're talking about if there's no repeal and no amendment, then just the World War II. As I've stated before during the roundtable, that's the problem. How do you determine if something is World War II era or not? So we encounter ordnance from all different eras. There's been some stuff as long back as World War I era ordnance. There is Vietnam, Korea era. There's stuff that we just can't determine. And so the problem becomes if the technician is looking at something and they can't determine what era it came from, then they can't do anything with it. And if we're trying to ask a technician, so, well, try to determine what era that came from, and then they have to hazard themselves by doing additional, scraping away on the casing or something like that, we're not going to do that. And so that's where we come to the 27th as we can't respond.
Okay, just to let you know, we are moving ahead with the bill, so potentially we can have an emergency session before the end of the month. And so, our intent is to address these safety concerns and not, pose any problem to the public. And in no way we're going to, have Guam EPA go out there and inspect those bombs. So there's no none of that happening. None of that going to happen. So yeah, ultimately, again, I want to reiterate that I think the intent is to amend the bill so that or clarify the bill so that emergency response is not. Originally the bill is written that way. There was no intent to affect the emergency response. So we tried to clarify that. And it seems like we need to clarify that a little bit more. So yeah, I think there's a way we can work with the bill so that there is no impedance to ensuring the emergency response is still done. So my apologies, we did have more people here to testify. So if there's anyone here that I missed, Robert Celestial, you can please come up to the table. And if there's anyone else that I missed, if you can come forward. Okay. Right. Thank you for your patience. You're recognized, Mr. Celestial.
First of all, I do understand that we're here for an amendment or a bill to amend open detonation. And so with that, I ask for your patience and your understanding. My testimony is in a history of Guam. And my name is Robert Celestial. I'm a Sergeant, U.S. Army, retired, disabled American veteran. Chairwoman Senator Sabina Perez, 37 Guam Legislature, an Honorable Admiral, and all the guests here. Manana Sizuas, Honorable Chairwoman and Senators of the 37th Guam Legislature. Please forgive me, I got really bad arthritis. Okay, here you go. Okay, there you go. My name is Robert Natmalik Celestial. I am testifying in favor of Bill number 3537 COR. Thank you for this opportunity to present a short history on why I support this amendment. I am an atomic veteran, and in 1977, 1978, I was part of a cleanup in the Marshall Islands, Inuitak Atoll. 43 nuclear bombs were detonated on the atoll from 1946-62. We handled and transported radiated debris to Rennet Island, which today is called a dome. I submitted a 4-page report, Radiation Fallout Guam, to all government leaders in 2001 because in 1994, President Clinton formed the Human Radiation Experiments Advisory Committee that declassified numerous U.S. government agencies such as the FBI, NSA, DOE, which is Department of Energy, etc. I found that exposure to nuclear fallout to the resident Guam and the washdowns of Navy vessels in Opera Harbor were kept secret for decades. I would like to read Lieutenant Bert Schreiber's sworn testimony that was notarized. Testimony of Lieutenant Bert Schreiber, Lieutenant U.S.N., retired on the fallout of first hydrogen bomb test. My name is Charles Bert Schreiber, now residing in the United States of America, state of Texas, Harris County, city of Bel Air, Inc. I have the rank of lieutenant, serial number 359684, and I'm retired from the U.S. Navy. My credentials consist of a bachelor's of science degree, major in physics with a minor in mathematics. I also completed a course in radiological safety at the United States Naval Damage Control Training Center, Treasure Island, California. I have a top secret military clearance dating back from World War II. I was also given the very highest civilian military clearance of Q clearance. Clear clearance, if you go on Google, is a top secret clearance given by the AEC, which is the Atomic Energy Commission, which is now Department of Energy. That means I have been vetted by the FBI twice, and my loyalty to my country is unquestionable. I volunteered for active duty during the Korean police action and was assigned to the headquarters command on Guam, reporting for duty on January 14, 1952. In addition to my primary duty, I was the radiological safety officer for the headquarters command. It was part of my duty to safely store and maintain Geiger counters. Victurion was the manufacturer, if my memory is correct, for the detection of nuclear radioactive materials. These were kept in a locker in the Bachelor's Officer's Quarters, BOQ, in the office of this building. I was the treasurer of the closed mess, and therefore this was my office as I oversaw the berthing and messing of the BOQ. The senior officer's quarters that I was housed, the messing facilities for all the officers in the civilian berthing facilities on October 27, 1952. I was detached and reported for duty to the Staff Commander, Naval Forces Camp Marianas. My primary duty was atomic, biological, and chemical warfare defense officer. Due to the political currents at that time, there was possibility of atomic warfare that could cause the spread of radioactive particles in the combatants. I therefore made sure that the Geiger counters were in the working order in case the emergency arose. As a side issue, I might add that any efforts on my part to convince the commanding officer, Camp Marianas, Admiral Ernst Leitch, USN, to inform, educate both the civilians and military of all rates and ranks of even the simplest life-saving precautions in case atomic warfare broke out was thwarted and denied. It might be appropriate at this time to discuss the Geiger counter, what a Geiger counter is. Not how it works. It is only sufficient to know that it detects the measures of a needle-type scale and 3 possible results of radioactive debris. Those are alpha particles for the nucleus, a helium atom, that are very dangerous if ingested due to their energy. Beta particles that are high-speed electrons that can penetrate a few inches, flesh, gamma rays that most know are just high-energy X-rays, all cause irreparable damage to the cells of the body, ionizing radiation. Geiger counters are capable of detecting the natural background of natural radioactivity or cosmic rays that frequently hit the Geiger name after the inventor. Tube inside it that does the detection. A single particle will make a click as the instrument has an audio sound output also. These 3 products, individually or combination, are given off to radioactive elements. Some decay very rapidly to non-radioactive stable form, while others take care of thousands of years. Those have a long half-life. How long it takes a small amount to decrease is radioactivity by 1/2. When incorporated in the human body, it can cause many types of damage that do not appear for many years after exposure. On or about November 3rd, 1952, I was making my monthly check sitting at a desk in that office that was about 5 feet from the window screens that covered the wall all the way down to about a couple of inches from the floor. I took out the metal calibration rod about as big as a normal soda straw and about 6 inches, stored in the instrument that has a small radioactive source on its end. I put the counter on low. It has 3, low, medium, and high, and was ready to place the rod near the detection windows, 2 of them, but the dial needle was way over the scale. An audible signal was clicking like mad, or almost a continuous sound, sounds like constant static on the radio. My original thought was the counter was malfunctioning, but when I raised it up and put it near the screen window, the dial swung even further, and the sound increased still further. I then put it close to the screen near the floor, and the needle went off the scale as far as it could swing right. I knew it was not the counter, but there was some radioactivity outside. I panicked. My first thought was that Guam had been subjected to some radioactive dust attack. I ran outside the counter with the counter, now on medium rain setting, and when I put it near the ground, especially where the rainwater that are falling off the roof of the BOQ, the reading was very large. In spite of the readings, the total was not an immediate life threat, but you wouldn't want to get any of that dirt on your body, or especially in your lungs, if you could help it. I then started running to the building where the Admiral office and my office about half a mile. I did not stop to inform commanding officer of the headquarters command, whose office I passed on the way. I went immediately to reception, bypassing my immediate superior, and spoke to the flag lieutenant, top aide of the Admiral, Lieutenant Commander GEA Holland, USN. I thought at least at the time that he was a good friend and we got along well on social level. I informed him of my findings and what they could mean and what the results were if something was not done, etc. He told me to go wait in the corridor outside the office. A few minutes later, the flag lieutenant came out and told me that I was to ignore the radioactivity and keep my mouth shut, period. And that's in large bold, period. I started to protest, but he told me to leave. I then knew something was very, very wrong. The cover-up, in quotes, had started. We weren't under attack, but something terrible had gone wrong somewhere. Though it was supposed to be a super top secret, almost everyone knew, but didn't dare speak or even hint publicly nuclear bombs of all types were being stored on Guam in case nuclear war broke out. Had something gone wrong with them? He was asking a question. The saddest part of this testimony is that the Guamanians, for the large part, had only rainwater for drinking, especially out in the boonies or jungle. They were drinking highly contaminated radioactive rainwater, and I could not tell them to stop. The Navy had control over the Camp Marianas region for about 1.5 million square miles Pacific Ocean area. Did not provide any information to the military personnel, civilians, or natives about how to protect themselves. Much construction was going on, raising a lot of dust that included fallout. Construction was not halted, or even instructions given to wear just a simple dust mask issued. It was several days before I learned that the cause of the radiation that I detected, I forget exactly when it was announced, I think it was 2 days later, that the hydrogen bomb had been detonated at Inuitak. I knew that many Guamanians and other natives in that fallout area would eventually die horribly from cancer, leukemia, subsequent birth defects, and too many other such afflictions to even list. I continued to check out the radioactivity daily, then weekly, then monthly. The quantity of radiation slowly dropped to shorter lifetimes. One finally went to, for all practical purposes, 0. The long-lived ones were still here, albeit diluted and dispersed in the dirt and rocks underneath. The questions that still haunts me to this day, did I do the right thing in following orders? Or should I have the courage to disobey my orders? Had I done so, I would have had to hide in the boonies for the rest of my life to avoid a court-martial and disgrace or even prison sentence. The prison sentence I probably would not have survived. The defense of, quote, I was only following orders, unquote, had been used by accused Nazi war criminals after World War II during the Nuremberg trials and had failed. This ends my testimony of fallout. However, it is not the end of one of the greatest cover-ups in history. I am going to write the epilogue to this testimony in hopes it can be included in the records with the root truth ever be told, much less the guilt admitted to the public and Congressman. This was Elizabeth Freund, my commission as far as it was notarized in Texas. And also, I just received this last year. Her name is Carol Ripley. It's a sworn, notarized letter. Thank you for your patience. 4 March 2022. This is my true and accurate account of an event that occurred between mid-1956 and mid-1958. My father was in the Air Force, and during the above state time period, we lived on Guam in military-dependent housing. We were aware that atmospheric bomb testing was placed in the Pacific. My father came home one day and said that an order had been given that families were to stay indoors 3 days during a certain period. A bomb had been tested and detonated, and the air currents were bringing the fallout over the island, which is Guam. My mother did not believe that 3 days was enough. Therefore, she kept her 3 children indoors for 7 days. At the end of this time, she had my dad went out and hosed down as much of the ash from the house as they could. They hosed down the yard and sidewalk until they felt certain that they got rid of as much ash as was possible. In her last months, my mother and I talked a great deal. She confirmed that my memory was accurate, and this was an event that did occur. In 1961, my father had benign mass removed from his larynx. In 1982, he died of cancer that was throughout his body. The Pacific Association for Radiation Survivors, Guam, has my permission to reproduce, store, submit, and use this document any way that will benefit the members associated. Carol Ripley, 1800 Frederick State, Owensboro, Kentucky, 42301. It was notarized by Gary Scott, Notary Public. I will continue my testimony. Okay. Makes you want to cry. From 2001 to 2004, it was ignored all my findings, and my report was disregarded to many levels. In 2002, the U.S. Congress passed another law asking the National Academies of Science to go out nationwide and find out what other geographic areas to include in the radiation exposure compensation program as downwinders, because several states were recognized downwinders for nuclear fallout and given compassionate compensation. In June of 2004, that's 4 years later, I was invited to testify and present evidence before the Board of Radiation Effects Research Committee of the National Academies of Science in Washington, D.C., which I did, and a year later, a report to Congress was submitted by the National Academy of Science, quote, assessment of the scientific information for the radiation exposure screening and educational program. The committee recommended on page 200, quote, conclusions. As a result of its analysis, the committee concludes that Guam did receive measure of fallout from atmospheric testing of nuclear weapons in the Pacific. Residents of Guam during a period should be eligible for compensation on RECA in a way similar to that of persons considered to be downwinders. In 2007, former Speaker Mark Forbes passed legislation resolution creating the Right to Know Commission to find information about Agent Orange and other defoliants and other similar types of chemicals that the people of Guam may have been exposed to post-war, period. For many years, it was denied that Agent Orange was never in Guam. The persistence of Speaker Teresa Lyer, Mr. Moore, and MVA, which is the Military Veterans Association, they worked diligently to prove that, yes, Agent Orange was used in Guam, and on August 2022, which was just last year, the Honor Pact that was passed to include Guam as an exposed area, and now veterans can apply for VA benefits if they were assigned in Guam from 1962 to 1980. The people of Guam have suffered for too long with cancers and other diseases that can be attributed to environmental toxins and ionizing radiation. We talk about the welfare and safety for the people of Guam and the military families. When you compare septic tanks to Agent Orange and ionizing radiation, the health damage that it can cause, it is not the same. Too many secrets and denials have been kept from us for decades. Let us not ignore the facts and pay with the lives of our people. In the end, it will be up to you, senators, to act and protect our people and the military families in and out the fence. Thank you again, and may God bless Robert Namalik Celestial. Thank you again, senators, and I appreciate your patience. I just wanted to make it a history. I know a lot of people might not think it's germane, but I think it's germane because we're talking about the health and welfare and the safety, not only for the EOD personnel, because I'm a retired U.S. Army, and I understand about being exposed to hazardous waste. And so I hope and pray that the Admiral and y'all can work this out and amend it where you'll be able to keep the people safe outside and inside the fence, whether it's at explosives that needs to be detonated, because when the Chamorro Land Trust Commission gave me 2 acres in Dededo, and we were clearing the area, I found a bomb. Well, the guy that was doing the clearing found a bomb in the property. So we did, just like the Admiral said, we called 911, mayor came out, fire department came out, everybody came out. EOD came out. They cleared the area, they surrounded it, they told the neighbors, that they're going to detonate it. And they detonated it, and it was safe. Then they took it out. Whatever debris was, they took it out. And I understand the process because I actually witnessed it. And so it's very important that the military continue to help the people of Guam. To, you know, if there's an explosive there, you know, it's for, to me, it's just to do the right thing. I mean, I understand the bill, I understand their concerns, but my history is that we just got to do what's right. You know, when I was stationed in Inuit Atoll, they didn't give us safety equipment. They just told us to go out there. And out of 8,000 of us, there's only less than 300 of us alive today. And so my testimony today is a history to inform you guys that when I started this in 2001, the majority, you were here, Senator Brown, majority of people, they even called me a kook in the radio station, saying, what's this guy, what is this, people with this? Military won't do that to us. Then years later, National Academy said yes. You know, the people of Guam deserve to be compensated as downwinders. Agent Orange, for many, many years, I know this, the scenario, you were in the legislature, Senator Duenas. You know, for many years, they say, no, there's no Agent Orange here in Guam. And then to find out that just last year, they passed a pact that included Guam. And so now the reason I'm testifying the history is because both sides need to understand the safety and the health risks for Guam. And that's why I'm here, is because please don't deny, you know, that the health and welfare of the people of Guam is more important than anything. So I thank you, and I thank the Admiral, you know, for his service, and everyone here. I just hope and pray we could do the right thing for the people of Guam. Thank you. Sijus Masi.
Dankaludanetsis Masi, Mr. Celestial, for that very powerful testimony. If you can also provide the written testimony from Bert Schreiber, Captain Bert Schreiber, as well as
Carol,
right? If you can
Yes,
include
I
that
will.
in your testimony, appreciate that. Yeah, thank
Anything
you.
else?
Thank you so much. Yeah, no, I think it's, yeah.
Okay.
Thank you.
Appreciate it.
So we do have another testimony that's going to be read into the record
Sure.
by
Sure.
Wineka.
Thank
You're
you.
recognized.
Thank you, Senator. I also just, before I begin, want to recognize, you know, Senor Celestial, his work, because what he's brought about is this long legacy of contamination and environmental racism that we've been talking about, and how there has been a lack of transparency. There has been a history of underreporting, and he's brought a lot of these issues to light before they've even been declassified. And I feel like his life serves as a very important example to all of us, you know, that when the people are saying that there are these real risks and real harms being done, we have to listen. And so I just want to thank him for that. You know, I also, if I can just briefly comment just on something that was, if I could just briefly respond to something that was mentioned earlier in Senator Lujan's questions. Last week, we were really grateful to hear the administrator's can-do spirit, is what one of our attorneys called it, to, you know, wanting to bring relief through drafting the necessary regulations for open detonation. But to hear today that, you know, these might be delayed 1 to 2 to 3 years, I just feel like I need to say that that's 1 to 2 to 3 years of more suffering for our people without those regulations. It's never been substantiated that these hazardous wastes are totally consumed through open detonation. That's never been substantiated, that open detonation takes care of all of that waste. And the fact that there has been a history of a lack of transparency and a history of underreporting, and also the failure on the military's part to look at alternatives in the first place when they try to apply for their permit application. You know, that's the track record we're looking at. That's the track record we're looking at, as well as the fact that they don't have a handle on the number of munitions that are still here wasting away. So now I'm going to read into the record testimony submitted from our Commonwealth 670, a community group in the Northern Marianas. This testimony is from Dr. Isa Areola, and they too are dealing with issues of open detonation from the Department of Defense munitions that have been left over through the various wars. Statement on behalf of OCW 670. We want to state for the record that we support policies that safeguard the health of our community members and our lands, given the outdated and hazardous conditions that open burn and open detonation create in our islands. The fact that unexploded ordnance still remains and needs to be collected and disposed of properly should remind the military of their wasteful and toxic legacy of contamination that will impact us long into the future. We view the practice of OBOD in this historical context. Rather than finding quick or more convenient fixes to these matters that harm us in the long term, we want to prioritize our people's health. We believe that the best preventative medicine promotes avoiding unhealthy habits to save costs rather than waiting to treat troops and civilians after their exposure to burn pits and their subsequent development of a myriad of adverse health effects and diseases. The ordinance reminds us to be cognizant of the generations to come that will bear the brunt of these detrimental practices if we let them occur. The proper disposal of unexploded ordnance shouldn't be a crutch for keeping such destructive practices around. Sizos Masi, and thank you for the opportunity to express our support for policies intended to protect our islands and future generations. And so that is testimony from our Commonwealth 670. And then just, further to the question too about, regulations, should there be an emergency? I don't know, Senator, if there's an opportunity. Now both of our attorneys have had to go to Zoom. They're still in attendance over Zoom, and if it's possible, if I can ask that another opportunity be allowed to Attorney Chow to talk about the federal regulations that remain in place that can, that if Attorney Chow is able to speak to that.
So yeah, there was a question I posed earlier regarding, for everyone to respond. So
Right.
I did start with the Rear Admiral. It was meant for the whole panel, so I can honor that request in regards to what, if they can make some clarification regarding the emergency regulations that are currently in place. Attorney Chow.
Thank you, Senator Perez. Bill 3537 provides that until Guam EPA issues the new rules and regulations, the current U.S. EPA rules and regulations apply. The military has been responding to emergencies and conducting open detonations under the current regulations as far as we know. And Bill 3537 doesn't change what is applicable come 8 days from now. What's more, Guam EPA just said that there will be a compliance schedule worked out. So where's the emergency situation is what we want to ask here. Is what we're being told is that despite the law not changing for 120 plus days, that in 8 days, DOD will start leaving the community on their own to deal with unexploded ordnance? Because if we pass the proposed amendments in Bill 3537, that's what's going to happen. The law's not going to change for 120 plus days. And yet we're still hearing, if I'm hearing this correctly, that DOD is going to leave the community to deal with explosives on their own. I want to be clear, though, that it's unacceptable to keep delaying and delaying. That's all we've been seeing. Mrs. Flores has told you what it means for the people to have to wait for relief. And so when we talk about these emergency responses, let's keep in mind exactly what's being done here and what's already in place. And like I mentioned, what's in place is that you're going to be able to keep doing what you're doing until the military, US EPA, Guam EPA, and the public work out a regulatory regime that is acceptable for everyone. And we believe that Bill 3537 sets them up to do so. And we continue to urge for the passing of this bill as is without any exemptions for emergency responses. Based on the information provided by JRM, most of the waste being open detonated in Guam are UXO for emergency responses. So this bill must address routine open detonation used for treatment, as well as emergency response, if we're going to address the human health and environmental impacts of open detonation in Guam. I want to reiterate a point that was made at the Thursday roundtable. In an October 11th, 2022 letter from US EPA Region 9 to Guam EPA, Region 9 said that alternatives have been used in emergency responses. In our written testimony, we'll attach this letter for the committee and anyone else to see. Alternatives need to be assessed and used when safe, and this must be in law rather than just left to the Department of Defense to do on their own. As I noted earlier, when left to their own devices, Andersen Air Force Base failed to do any alternatives assessment and claimed that none exist, despite the existence of 2 to 3 alternatives being available once Guam EPA started pushing back. We can avoid these kinds of situations for emergency responses as well by passing Bill 3537 as is to ensure that these assessments occur for emergencies, and that such assessments can be worked out during the rulemaking process to ensure emergencies can still be safely responded to. And to make one final point, we keep talking about open detonation in these instances where it's necessary. Again, no one is saying that let's stop that from happening or to make it unsafe. But let's also remember to talk about what this bill was meant to address in the first place: the dangerous practice of blowing up hazardous waste munitions in the open with no controls whatsoever. The National Academies of Sciences listed a variety of toxins and dangerous materials that commonly are ejected from open detonation activities. You can find this on pages 7 and 30 of the National Academies of Sciences report, which we'll attach as well to written testimony. And the US EPA memo that they released on June 2022 said that there's no way to achieve total consumption of the hazardous waste through open burning and open detonation. So while it may seem like it's safe at the time to blow up these hazardous wastes, whether it be on the beach at Anderson or in place, it's not been substantiated yet that it's completely safe, that there aren't any remnants or hazardous constituents left around that pose a threat to human health and the environment. And EPA Region 9 also said itself that specifically for Anderson, in the absence of any groundwater monitoring associated with the permitted units, Anderson can't demonstrate that there's no release or migration of the waste treated in the unit required in the unit. And this is a threat to the groundwater, which supplies 80% of the island with its drinking water. So considering these and the other risks associated with OD, we have to ensure that open detonation only occurs when it's absolutely necessary. And this bill does that. It further ensures that possibility by allowing for current regulations to apply while these things are being worked out. But remember, we can't keep delaying. So to the points, all the points that are being made, we understand that these things can take time, but the time can't be paid up only by the community members. There needs to be some haste here, and this bill allows for that. It allows for time while also lighting the fire that's needed to provide the relief that the community deserves. Thank you.
All right. Thank you, Attorney Chow. I'd like to open up the floor to my colleagues. Senator Duenas.
Madam Chair, and while I can respect the fact that this looks like more a courtroom proceeding now than the public hearing on this bill, I think it further illustrates the Admiral's position on this. So let's get back to the bill. Walter, EPA Administrator, do you have legal counsel present today?
She's not presently here, but she should be online.
She's online?
She should be listening in, but that doesn't mean I have communication with her right now.
So do you have anything in writing on your from your legal counsel's review of your testimony in support of this bill today?
Yes, sir. So our written testimony, which will be submitted in the week, it has combined review by Guam EPA's legal counsel as well as just assistance from the region. Thank you.
Do you have written in email form or in black and white form from US EPA supporting your position here and that it would absolutely support your primacy that you've put on the record?
There are a couple of things that that their attorneys reviewed that said could go either way, but they were content that based on the regulations that we would have to implement, as long as we kept it to that side of the primacy, that we would maintain primacy.
And I think that's the important thing.
Yes,
what
sir.
you would have to implement. You don't have them implemented right now, Walter.
No,
and
we
you've
don't.
even declared that this 180 days would almost be basically impossible to set the parameters for what this bill calls in terms of being able to give a permit or to even assess alongside. That's problematic.
That may be, again, it would be the discussions with us and the stakeholders. Again, on Thursday, what was reported out in the roundtable is we've been doing a lot of work the last month and a half, 2 months, where this has been as much as everything that's going on, marine base build, baseload generator parts coming in, all of that going on. This taking up a lot of our time as well. That incorporates us working with the region, trying to identify communities that have adopted OBOD regulations similar intent to what the bill, or what the law already has and what this amended bill is requiring us to do as far as coming up with draft regulations. So again, it wouldn't be starting from scratch, but it would be very difficult to meet. Yes, sir. I do
Walter,
agree
we
with
have
you.
7 days.
Yes. That 7 days is something
You're aware of
different.
that, right?
Yes.
Right.
The-
And I think this body, in terms of having to act, and I'm glad that you said you're glad it's in our court.
Yeah, it is in your.
Because you're absolutely right, it's in our court. Because if we fail to address this, and with all due respect to what the Admiral has put in writing for over 60 days now, being very clear in terms of the actions that they have to take to provide security, not only for their personnel, but for all of the people of Guam, that they are prepared in light of not repealing this section on open detonation to discontinue all of that operation. That's what's on the table here now, Walter. So I can't go on. I respect the work you do. I respect the work your team's done. But you've demonstrated nothing this morning that you have a clear, concise go ahead from US EPA on your primacy and on the fact that it wouldn't even exist beyond this. And you have no clear evidence at this point that you could execute, and that even during the 180 days, regardless of what Earth Justice, with all due respect, they are not representing Guam. They are not representing any liability on Guam. They are not representing anything in terms of what might happen to our people on Guam. They're representing an opinion. So I just want to be clear so that it's on the record, because I'm preparing to introduce a bill to repeal this section. And I think you should actually go and speak to the governor and request that she support that. So I just don't think we're in a position to tinker around this. Thanks, Walter. Admiral, I want to get you back on the record because we just have to be clear here. But I think it's important for you to be able to be ultimately clear to the people of Guam of what we're doing here. You have been on the record now saying you have no problem with the open burn section of this law that is passed. You clearly haven't done it for 2 decades, and you clearly will only do so going forward under U.S. and local approved EPA regulations. Is that correct?
That is correct, sir.
You're asking us now to address a very, very dangerous portion of the current public law that under your legal review will not allow you to continue safely or legally to move forward and put your men and women in harm's way and the people of Guam in harm's way to address unexploded ordnance on base or off base because of the way the law is currently written, and that the current proposals in the amendment to amend the law without amendments will not suffice for you to conduct operations past February 28th.
That is correct, sir.
Another thing I think is very important, because I think it's important for the people of Guam not to deal with speculation. There was a comment that in the future, munitions and open detonation will be a high-powered, extremely powerful munitions, and this is going to happen on the base. I want you to basically put it on the record. There's absolutely no plans for that, and you would not support anything like that.
Sir, the ranges that are being installed are for small arms, machine guns, and we do have a grenade range that is being built as well too. But it is not it's not bombs. It's not very large explosives. There's several other inaccuracies that we're talking about today as well too. I just want to put it on record. There is groundwater monitoring at the facility at Anderson. That's been stated before that there isn't. That is not true. Thank you.
So, Admiral, I want you to address one other thing, just so that we understand. We all live by the same rules. This talk about open detonation happening on the base or on any military square inch of property that is currently under U.S. DoD control. Do you only detonate unexploded ordnance that is discovered upon?
No, sir. The vast majority of the ordnance that is detonated is the unexploded ordnance that's found either on the base or off the base or in the water surrounding here. There is some ordnance that is, for example, there's ordnance that's used for training. So at an unused airfield on Anderson Air Force Base, for example, we will detonate small amounts of explosives to crater the runway, so that way training can occur with the folks that we have, either the Red Horse Squadron from the Air Force or the Seabees that will go and practice runway repair. So they are practicing on a regular basis of how we do things. So there's training that happens with that sort of explosives, or also with smoke markers and these sort of things. And then finally, there is, for the ordnance that is stored at Anderson Air Force Base that has expired but is in good condition, for that ordnance that has gone past its usefulness, some of that ordnance is also detonated at the facility, at the permitted facility at Anderson Air Force Base under the current permits and regulations.
Meaning under the current permits and regulations, following all current up-to-date EPA standards.
That is correct, sir.
You know, Madam Chairwoman, I think I've heard enough. I just don't think we've mentioned that there's possibility for emergency session. I don't see anything scheduled for emergency session. So absent that, I will introduce a bill then to repeal the section, and we can call emergency session based on that. Thank you, Madam Chair.
All right, thank you, Senator Duenas. Senator Joanne Brown.
Thank you, Madam Chair, and certainly good morning to all of you that are here to testify on this bill. I know, Walter, you're coming maybe on your 30th anniversary. You still got a couple more years to go, because I was at Guam EPA 30 years ago, serving with Randy Sablan as Deputy Administrator for 3.5 years. So we're challenged, all of us are challenged coming to the table, whether you're in the military, you're a civilian, or you're Guam EPA. We recognize that there have been many, many, many years of abuse with regards to disposal on this island, in addition to the fact that we are the victims of war, an active war that occurred here on the very island that we live in. And so we are affected so many years later, almost 80 years later, as a result of that, including the bad environmental practices that happened here. And, you know, it was part of the learning and the growing process. I think we all recognize the challenges with that, and certainly we see it in the health and welfare of our people, because we have such a high percentage of these illnesses, including cancer. I don't know anyone, if not yourself, an immediate family member, who's not been affected, who has not suffered, or in my case, who has died from it. So I think that is the challenge we're all faced with because of the history of our circumstance. And then also, of course, you know, ensuring that what we're being told is true, because of the challenge we've had in the past, because our people were not informed about the dangers that they were experiencing. And we're only finding out years later, and certainly appreciate the efforts of Mr. Celestial. And he's right, you know, 20 years ago when he was here advocating these issues, many people thought that he was making it up, that there was no seriousness to the issues that he was bringing forth, because if it was true, imagine the implications, and those are the things we are experiencing and we are being affected by, and things we worry about, that our children or our grandchildren and those that come after us, are they going to inherit the burdens and the illnesses that we have inherited? I served for 14 years on the Restoration Advisory Board, and while I understand the military gets hit often, even though I myself am from a military family, my dad's retired Navy, I know a lot of efforts have also been put in place to identify and address mitigation and cleanup of many of these sites. Millions and millions of dollars have also been invested to address cleanup. So the military has the additional challenge of dealing with their own federal counterparts with regards to ensuring, moving forward, that they follow the safety procedures and the requirements that are in place. And yes, efforts have happened, some have failed. Erode Point is a very good example of that. They spent millions of dollars to cap Erode Point, only to have, you know, the contaminants still to this day seep out. We recognize that. The landfills at Anderson, there's many areas there, you know, where they directly excavated into the ground and simply dumped and disposed munitions, chemicals in barrels, not even knowing, or indiscriminately, I guess is the best word to describe what happened there. I know because I've gone and seen many of these sites and involved in the cleanup of that process. And so there we are, and here we are today and having to deal with this. I think we recognize with regards to the most pressing issue is the emergency response. And we understand, Admiral, I mean, I'm no expert in dealing with bombs. We were just raised in a generation on Guam when we had EOD specialists come to our schools when we were students, showing us pictures of what, you know, a bomb looked like, what a hand grenade looked like. Also pictures of children and others that were injured. There are very graphic photos. Certainly for kids, you're really taken aback by it, but thank goodness they did, because some of us have come out, it could even be something as simple as a bullet that we come across, and it's not as uncommon as one would like to think, but we grew up in that generation. I'm sure even your EOD experts just trying to rationalize in my mind some cases, they're not going to be able to tell all those details looking at a bomb that may have been in the ground for close to now 80 years. And determining, I'm sure they have the expertise to deter, because we don't. And I don't believe anybody else here in the government of Guam has the capability of being able to address that. So certainly if we end up finding a bomb in the ground because the result of construction or becomes unearthed or someone simply comes upon it, we know we don't have the capability of addressing it. You have the capability of addressing it. And we have to rely in that case on your judgment. What is the best means to address the disposal, especially if they determine it's an emergency and it needs to be addressed. Because we don't want to create another situation of harm to your personnel and also to our community at the same time. And I'm sure that call would be made and determined as a result of that. So certainly what we can do to facilitate that, I think it's very important. I understand the efforts and the work of our good chairwoman in wanting to facilitate this and moving forward, making sure that the safety measures are in place. That as we have to address these issues, as you mentioned, old munitions, old bombs that are going to end eventually, if not always, be phased out. How do we deal with it? Some of these things you can't take off island. And that's another sad reality that we have to deal with, but we have to deal with it in the most appropriate way. So I certainly would be supportive of what we can do to make sure there's clarity with regards, especially because the most pressing issue for us is emergency response and the ability for you to do that. One of the things I think we're still going to be stuck with in this conversation, just from the testimonies collectively provided this morning, is we're still going to have to determine how do we get to that point where we collectively agree on the language. And that may take a little longer. I know the legislature may proceed with this bill, legislature may proceed with any other bill a colleague here will introduce, but I think until we get to that point where we collectively agree, we're not going to get anywhere, because we may change the language, it may be agreeable to us, but if it's not agreeable to you, then you're not going to be able to perform the work that we might need if another bomb is unearthed on Guam. So I think that I walk away this morning with that understanding. I think we should all collectively walk away with that understanding. So I do hope we come to consensus. I think we have a mutual interest that we can come to consensus, and I would like to see us do that. And certainly for Guam EPA, I hope you can facilitate the work with regards and prioritizing these regulations, because I think you can see from a community standpoint, I appreciate the advocacy. I appreciate seeing more and more of our people very concerned about the quality of life. Of course, I want to see it across the board. I don't want to see it just with the military. I want to see it with private developers, because I don't see the same aggressiveness. I don't see the same complaints when, you know, our ancestors' remains are unearthed on a private project and not been properly interred. I don't hear the protests. But certainly if you did it, oh God, God help you. You never hear the end of it, right? I just want, you know, if we're going to do this, let's be fair across the board. And let's also be very much aware that that's something we as a government, we as a community, and certainly Walter with your oversight at Guam EPA, we need to ensure that everybody is doing the same thing at the table, because we do rake the military over the coals, so to speak, on environmental degradation, environmental cleanup. We don't do the same with everybody else. And we know those violations equally are occurring and equally can cause adverse impacts to our environment and the quality of life of our people. So I just like to see fairness all around. If we're going to beat everybody up, then let's be equal with it with regards to ensuring compliance across the board. With that, I don't have any other questions. I don't have any questions to ask. I just hope, again, if Guam EPA can facilitate, and I do hope, Admiral, that we come to a consensus with regards to language so that we can mutually move forward with what's in both our collective interests. With that, Madam Chair, thank you. I don't have any further comments or questions.
Thank you, Senator Brown. Senator Taitigui.
Thank you, Madam Chair. Good afternoon. Thank you for hanging in there with us. This is something that's very important as well. The roundtable was quite long as well. I watched that. I was off island, but I made sure I tuned in and watched that. That's why I was wondering, Walter, when you mentioned in the round table that 120 days is doable, but you just mentioned it's highly unlikely now. I mean, what happened from last few
Senator,
days ago?
I'd never said it's highly unlikely. I just said it's...
No, I thought you said that now. I mean, during the round table, you never said highly unlikely, but now you're saying highly unlikely.
Yeah, I think that came from Senator Lujan. I said we would make do what we did, and we are working on it already. Again, I don't want to put a cap on my team because the team is awesome. So even though they're kicking me under the table, I know they can do it if they need to be. And again, the distinction I want to make is the regs, again, would be draft regs, which, of course, at any time, this body could change the verbiage we use. Even if we came to a consensus with the regulated community, DOD, and the private sector, it's still within the power of this body to change the verbiage that we have there. So again, it's just one of those things that you deal with. So again, having that time frame, it wouldn't be convenient and it wouldn't be optimal for us to really, vet some concerns. We would still, I don't want to put any caps. I know my team can do it, and it's, I think Maneka said it's the can-do attitude. That's
In
what we
other
are.
words, Walter, it's doable, right?
It is doable,
We do
yes.
understand that after the rules and regs are put in place, that in the rules and regs, there are going to be timelines to implement this and, come into compliance. We do understand that part.
That is correct, Senator.
Yeah,
Thank
so,
you.
but it is doable, 120 days. The other question I have is, Walter, when it comes to these permits, emergency permits, is EPA available 24 hours to, in the event, someone discovers a bomb? And the first thing that usually in the community is that they'll call the police department. I mean, that's first 911, call the police department. And from there, what is activated?
Okay. So if you don't mind, Senator, let me just take a step back.
Sure.
So as far as the current RCRA requirements, emergency permits are not a requirement at this point. What we're talking about is, and again, I use the term permits during the roundtable and in previous discussions, and it probably should not be used the term as a permit upfront. In retrospect, it should be notification. And the notification then tells us that, yes, what they're doing is something that we should be privy or have knowledge about. And that's where then you can write and this is, again, in discussions we have for our draft regs, well, then you do a after-the-fact permit, which just basically tells you everything that you've done and why you did it. So that's kind of what we were looking to do in our draft regulations. Now, as far as being able to contact Guam EPA, we are part of the emergency response system notification that Guam and 911 has. And so that we do have a 24/7 emergency response phone that is manned 24/7, 365, or leap years 366. But the other caveat that we also discussed about doing that in the event, and a very unlikely event, that Guam EPA is not able to be notified about open detonation that needs to be taking place during an emergency situation, that we would also have, as the powers that be, in consultation with the region, US EPA Region 9, that their 24/7 number is also available. And their number, they could easily contact us. So it would not just be contacting the local government, and again, if that fails, our contingency would be you contact the federal regional on-scene coordinators, and they in turn can give that same approval and notification that we got it. They will make sure that Guam EPA knows about it, and then after the fact permit can happen. That's kind of how we're looking to do that.
Okay, can you run through it, just for layman's terms, just tell me what happens if somebody calls GPD and says, there's a bomb in I think there's a bomb in my backyard. What is the first thing that happens? And they call 911, and what happens after that?
I believe that, I don't have the full procedure out, but 911 notifies the Office of Homeland Security, or
Right.
Office of Civil Defense, and then they go through their protocol. And as part of UXOs, Guam EPA is one of, I believe, numerous agencies that need to be contacted and informed. That doesn't always happen for whatever means, but then ultimately what will happen is Homeland Security, Office of Civil Defense will contact DOD, and depending on what portion of the island, whether it be the southern or the northern part, appropriate EOD team either from Anderson or for Navy Base Guam will respond.
So Homeland Security has a lot to do with this then, right? Oh, wait, you know what? I tell you what, I saw Admiral saying that he might, and good afternoon, Admiral. Please go ahead. I saw you.
Yes, ma'am. Just to clarify the process. So
Okay.
Guam PD gets a call, or Guam Fire, either one. Whoever the local resident calls, it doesn't matter. They basically call 911. So the 911 dispatch for Guam proper, they are connected to and they talk to our DOD regional dispatch that falls under me. So that is the call that's made to the DOD regional dispatch. From there, that is where a determination is made at the regional dispatch where the location is. If it is north of the airport, then what happens is our regional dispatch then contacts the EOD team at Anderson Air Force Base. If it is the airport in south, or if it's in the water, then the regional dispatch contacts the Navy to do the disposal. So that's how that process flows to get to our EOD members. So there is a connection, and this happens for not just explosive ordnance, but any 911 situation that when the government of Guam determines, or the 911 dispatch determines they don't have the capacity or the capability because it's elsewhere, then we dispatch our Department of Defense fire and emergency services. Often ambulances is the one that's called out the most. But that is where that connection is made, and so our teams then are dispatched to that location, and they report on scene to whomever's there. Generally, and I have experts here that can talk specifically to it if you'd like, but generally the area is cordoned off generally by Guam PD, and then the team goes in and then they go examine what's going on and make a determination there what the right way to go forward is.
So Homeland Security is the one that makes contact with you at that point?
There is a connection directly between Guam Dispatch 911 and Regional Dispatch. So this is, to my point earlier, there are a number of other folks that are contacted, Homeland Security and a host of others. But when it comes to the actual emergency response, the people that are going to go take care of the problem, that is 911 center to Regional Dispatch, which is basically the DOD 911 center, and then that goes to the teams. So there's a very streamlined process to make sure we get experts on scene as soon as possible.
And then what happens is the GPD, they pretty much rope off the area to keep the area safe?
Actually, ma'am, I would like to have
Okay.
one of our EOD technicians, the head of our unit that does this.
Sure,
He could
please
answer
come
that.
up. Yeah, and the reason why I'm going with this is the concern that you have on your, some of the recommendations on your testimony, number one, and then number two, which is basically, you know, hand in hand. They're almost the same, number one and number two. And I'm trying to figure out, why are you wanting to allow an open detonation for emergency and munitions response continue without permitting and alternative technology requirement? So I just don't understand why, and now you're mentioning permitting is not really permitting. So you can respond to a bomb, right? And not have to go to EPA and say, EPA, I need a permit to detonate this bomb. Is that right? That's how it's going, right?
Before the law, the current law was passed here, the emergency response falls outside of RCRA. And so we did that separately. It's a very, very complex subject, and I apologize. We're trying to walk you through it, but it is very complex. And so, yes, prior to the law that was passed here, in the same way it's done across the rest of the nation, there is no holdup to let the bomb squad go take care of a bomb. That's basically what it boils down to. So I'd like to turn it over to Lieutenant Moyer, if I can, to talk some more specific. Yes, ma'am.
But before I do that, so the previous law, there was no stopping you from just responding and doing the detonation, and then 30 days later you provide this information to EPA. But the current law that was passed now says that you can't even detonate without notifying EPA first and then detonating it?
So the the bill that's under consideration right now, and this is what I called out earlier, the language is not clear enough. And so although the Earth Justice attorneys think that, oh yeah, this gives you what you need to do, the DOD attorneys look at that and they say, no, this means that you have to get a permit before you go and do the response. And that's what I'm concerned about is we have to get this language right, that everyone is on the same page, because we don't want to hold up those folks from getting there on scene, because it may be, and it's happened before, where we get something that's extremely dangerous and we have to actually take care of it right away. And that's very problematic. That's what I don't want to hold that up.
So the current law right now, currently, the one that passed in the 36th Guam legislature, still allows that for you to go and address, but you're saying, no, you're not clear.
The current law also has us make a determination that it was World War II era.
Oh yeah,
and that's,
I do understand
there's a number of different problems here that get conflated with each other, but there's certainly a number of different issues that we have to work through to be in a good place, ma'am.
Walter, one minute. Okay, Walter, have you had any issues at all with the prior law? I mean, before Public Law 36 was passed, the one last year, have you had any issues at all?
Issues in regard to what, Senator?
A bomb not being able to be addressed, detonated.
Mean on the emergency response aspect of it?
Right.
None.
None whatsoever?
No.
Okay.
Of course, the intent of the law of having us being able to review and understand just a little bit more of what's being detonated that we could use.
Okay,
but
so I think that's
more an administrative side, but the actual response side, it's been really good. I don't think the military has never said no.
Does this current bill that we're addressing right now allow DOD to come in and address any bombs without having to call EPA for a permit?
And that's where I think the Admiral and also even our legal counsel, as well as the regional legal counsel, sees a little gray area that can be interpreted
so it's just
a couple
verbiage.
ways. Yes.
Okay, it's just verbiage.
But again, what was done in the past is notification did come to us, especially like Navy when they're doing their training, they find UXOs and they want to do it for training, they'll notify us. Again, it's not really a mandated law, but they notify us, and then we would remind them, hey, you need to just fill out the process, fill out the forms and turn it to us. So this just kind of lays it out with an agreement that we have with them already, lays it out as part law, so it just strengthens what we do. But again, for emergency response, I have not seen any failure on DOD side to respond as well as to notify at this point.
Walter, after, let's say there's a bomb that's been detonated, and in the law it says you have 30 days to report this with all the information and data to EPA. At that point, does EPA come out to the area that was detonated, or are you there during the whole entire time to ensure that, if there is any kind of contaminant that you see or anything that looks just really bad for the environment, or you wait for that 30 days and then go out to inspect the area?
So a good question, Senator, and something that we've, at least in my tenure at Guam EPA, we've never really done as far as open detonation. We've done, and I'll correlate this to other emergency responses. So like if there's a big oil spill and we respond, of course compliance and cleanup with that oil spill is mandatory. And then because we have more technical expertise on it, we will mandate some monitoring, some sampling to ensure that the spill was cleaned up adequately. We do not do that currently with open detonation, and maybe it's just things that we actually, because of our renewal for the OBOD permit for Anderson, the guidance that US EPA provided, and all the other things that has occurred since then, we're realizing, well, maybe we should increase the monitoring, just at least open detonation, depending on what was detonated. If it's something that, like a pineapple grenade that came from World War II, sure.
Well, I think, Walter, that should be done right now, today. We don't wait for 120 days on rules and regulations. I think that's something that EPA needs to monitor. I mean, should be there when they detonate it, should be there afterwards to test any grounds or any soil or anything that has caused any damages. Admiral, the open detonation and open burning, the two of them combined are in one permit, correct? Okay, do you have any problem with taking away the open burning and making this permit just strictly open detonation?
I have to, the permit was submitted by the Air Force, so I can't tell them that. I would have to go back through to the Department of Air Force. The indications I have from talking with the folks in the Department of the Air Force and from their lawyers, we really wouldn't have a problem with taking away the open burn. We haven't done it for a long time. As I said before, it's for bulk propellants. We don't store that kind of stuff here anymore. So I don't think that that's going to be the biggest problem there. But and that actually, in the permitting process, in the permit that was already submitted in 2021, Guam EPA has the ability to go through that and only approve certain items. So there was already a process that we could have just followed that would have, done the things. We could have done this without having to come to where we are today.
Okay, so go ahead, Walter. I know you're going to say
Yeah,
something.
and I just want to point out that with the current permit, even though we are not done evaluating it, our initial response to the Brigadier General was that you are to close your open burning portion of your facility.
Okay, the other one is, Walter, with regards to the MMR that was discussed in your 5.5, are you considering including the MMR, or do you are you very familiar with the MMR?
Yeah. So we've been looking at that for quite some time. I've had the good fortune. I've had the fortune of being a lot of legacy work on the island as well as seeing elsewhere. And so we follow a lot of the MMR on the surplus side. We are looking to see what differences it would make, but it is considered a very solid document that maybe, like Senator Perez mentioned, may need some refinement because it was issued a couple of years ago. But yes, we are looking to adopt that as well as maybe add some amendments to it so that it meets our time now. Thank you.
Admiral, do you work closely with U.S. EPA at all, especially on this situation here? Have you made contact with them and discussed
Yes,
this?
ma'am. So for the Department of Defense, I am the Regional Environmental Coordinator for the Pacific Islands, which falls under EPA Region 9. So yes, we work very closely with them, and I have a number of environmental attorneys that work directly with US EPA Region 9 on a regular basis.
And I'm sure Walter listens quite a bit to US EPA. I mean, a lot of funding comes from them, so we have to make sure that it goes hand in hand. So at least you're on the same page there. You're getting the same email, not one person saying a different story than the other. So at least that's good. Okay, the other one is, Admiral, it mentioned during the roundtable about chambers where you're able to safely detonate ammunition in a chamber. And you mentioned that not a lot of, some of the chambers are not large enough in some areas, but do you have these chambers here on Guam? If not, why not? And what capacity? I mean, bomb is about this big, right? Especially World War II or Korean or something, or about this big, right? So the chamber really is not that big, right?
No.
Okay.
So.
Okay. So help me,
right.
educate me on this chamber.
I'm sorry. I could have brought some pictures and stuff. But I didn't know we were going to be talking about these specifics. But for example,
the only reason I'm bringing that up is because if you have that mechanism right now, I mean that's a safer way than just detonating it right now.
We do not have those here on Guam.
And why not?
Okay, so let me go through that.
Please.
All right. So the chamber method is really restricted to smaller amounts. When you talk about say a 500-pound bomb, the chamber for that, first of all, and I'd have to go back and look at my notes, there is an actual upper limit on how big of a chamber can take. So for very large bombs, you can't do it at all. But the chambers we're talking about they're very, very large. Maybe half the size of this room. It's not a small thing. The small ones are for really small items. Now, it's very often mistaken when you see the explosive ordnance disposal truck that's going down the road and they tow behind it, looks like a sphere, right? That is just for transportation. And that's just for if in an emergency something happened, but that would be kind of a one-time use thing that if it blew up. There are smaller chambers. It was mentioned earlier about there are places where unexploded ordnance is taken care of by alternative methods. One of those places, for example, is the island of Vieques. But the difference there is that's a bombing range, or it was a bombing range for the U.S. Navy for a number of years. So they know exactly the things that have been put there. And in the case of that chamber that they used there, it's just for the fuses of the dummy bombs that were done. So it's small. The problem we have here is the vast amount of different types of ordnance requires different types of ways to treat that, right? So it's the alternative methods that are out there today that are in use that we talk about often, those are at our arsenals. So like the Redstone Arsenal in Alabama, they produce this kind of munition, and then when it's expired, it goes into a particular system. For most of the technologies, it requires some sort of a disassembly of the unit, right? So we're talking, if you think of a bomb and it's all shiny and new, but it just has passed its prime, it goes through a process where it is disassembled. The fusing is removed. It goes into a particular chamber. There's several different methods. One uses what's called bakeout, which slowly heats up the ordnance to liquefy the high explosive, and then that is collected. Another one uses a water lance, which washes it out. Both of those methods create a secondary waste stream for which we do not have the capacity here on Guam to store that waste and then treat that later on. So that's one issue with it. But those chambers are built for specific, those chambers and other methods are built for specific types of ordnance. Here on Guam, the amount of ordnance is enormous in the numbers and types. And so that's one problem. The other problem is, especially with the unexploded ordnance that we find, because it is so old, it's mostly rusted together. So the ability to take it apart and to put it in one of these methods, it just doesn't exist. So should we be looking at some additional things? Absolutely. And that process is going on right now to figure out how we can do this. But right now, we just don't have those capabilities, and it would be pretty extensive to be able to figure out, we need this for this kind of ordnance, that for that kind of ordnance. It would be a pretty thing. And I'm also very, very concerned about the secondary waste streams. It's easy to talk about, oh, you're going to treat things this way and that way. We have a problem right today with how we ship off hazardous liquid waste from the island because there's not a lot of shippers that will do that. You would be creating a significant amount of hazardous liquid waste that we're just not set up to deal with at this point. So there's a number of different issues that come into this.
Thank you. I think everyone gets a clear picture of how far it's going to take us to be able to do this safely, but it doesn't stop us right now from, ensuring that there is any kind of cleanup that needs to be done right now, and monitoring and doing any kind of other alternative to avoid contamination to our land and to our water. So it's very important. I really appreciate it. And I don't want to leave you from explaining. Please state your name and then go ahead through the process. And by the way, is National Guard also involved in this too, the Guam National Guard? Okay, go ahead.
So I'm Lieutenant Jason Moyer. I'm the Navy EOD officer in charge. The Admiral described the situation and the process fairly perfectly. Just to go back several questions, when we arrive on scene, depending on what the reported object is and where it is primarily, we will have GPD set up a cordon to ensure safety for local residents, neighbors, things like that. That's going to be location and ordnance type specific, but the Admiral described the process as it goes. And then as he got into the process of containment vessels, yeah, there are several different containment vessels. Some are noted in the alternatives study that is referenced throughout this bill process. Large containment vessels for disposal purposes that the Admiral's speaking to are the ones that are going to create secondary waste streams. And they're usually implemented in places where the life cycle of the ordnance takes it. And he described it well, right? This ordnance item X is created in City 1. When its life cycle is up, as determined by studies and research and current military processes, it will get shipped back to City 1 for its life cycle completion at that facility. That's kind of how the current process for ordinance development, testing, and usability works. And so that's what he's saying. On Guam, we don't create any ordinance here. It's not an arsenal, like as he described. It's not an ordinance depot. So we don't have those facilities available.
Okay, the question was, really the process. So when GPDA is called, they rope off the area. It's contact through Homeland Security, Civil Defense, probably fire. Everybody is called, and DOD especially. And then DOD comes out to the area, inspects the area, keeps it roped off, and that's the process. But during that whole process, you don't have to call EPA for an emergency permit or the authority to detonate at that time. Is that correct?
As the responding EOD team, no, ma'am.
Okay.
If that exists somewhere else,
So-
as the director
Okay.
previously mentioned, I'm unaware of it. But I would strongly advise against that from my current opinion and priorities, because that just adds one more layer of administrative burden that we have to do before we can actually arrive on scene.
I agree. I mean, it's an emergency. It needs to be done right now, but I think EPA should be there at the scene too as well, just before any detonation is done, to oversee the project, or, just to go ahead, Walter. And you do that, right, Walter? As soon as you
So-
hear about a bombs in the area,
Yeah,
EPA
so-
goes out there, I hope so.
Currently, we do get notified on a pretty consistent basis. I do want to state that because we are not EOD, because we're not the technicians, we do not want to take their job. We do not want to make the assessment that they do. We do have ample ability to talk with US EPA about guidance and whatnot, and sometimes they may say, well, maybe that wasn't such an emergency, but that's besides the point. That is not our job, and nor do we want that to be our job. Our job is strictly to be notified, and as stated earlier, maybe we need to enrich our knowledge a little bit more about, when the type of bomb is detonated, if full combustion or detonation has occurred. If not, what we can ensure that there's nothing left in the environment, especially anywhere on the island. The other thing that we also don't want to be is to prevent them from doing their job. And again, that's why we kind of swayed to the term notification, because then it's just simply telling us. Now, the EOD team may not be the one filling out the report, but usually the environmental directors have that task of filling out the report for that EOD team, and that usually comes in within 7 days after the detonation. But the one other thing I did want to point out is that when I mentioned, and again, this has been discussed on different levels, there is not one alternative based on the waste stream and the explosive waste that has been identified that could be detonated. There's not one alternative technology. I know Senator Lujan quoted me as saying 2 or 3, and that's just 2 or 3 that we know may be needed for all of the different explosive waste that you can encounter in Guam. There may be more, according to, just what the Admiral said. Not everything is discernible that we know is out there. So there may be others, and that's why the verbiage in the bill, whether we go with this bill or do whatever this body decides, the verbiage about, what is the best alternative technology available is a good term, because we don't know we know that not every alternative technology is a do-all for all explosive waste. That is not true at all. So that's why I use the term, there may be a need for 2 or 3, maybe even 4 or 5. I don't want to put a cap on it. And again, it goes with the statement that Guam EPA nor US EPA is going to determine what type of alternative technology is to be used. That is to be for the permittee or the entity that does that work. And then we just approve to make sure that it meets the waste stream that they're designating that alternative technology is used for. So again, we know it's not a one fits all.
Yeah,
So,
thank you, Walter.
yes, you're welcome. Thank you, Senator.
I thank you, gentlemen, for being here. And of course, we want to work together. It's about protecting our island, keeping Guam as beautiful as it is today, as it will be for our future generations. And that's what it's all about. We all hold the same passport. It's a U.S. passport. So let's all work together, and I'm hoping that the connection with US EPA, where both of you are working with, and if the language is conducive to them, then of course because of DOD you have to follow US EPA's guidelines, then I think it'll be a win-win. So Madam Chair, with that, I ask that US EPA continue to be at the forefront in the language, because it seems just the language issue. And if US EPA agrees that this language does exactly what it's intended to do, to not hinder the detonation of anything that's very harmful to this island, but also keeping the environment in check, I think that's the one that we follow in the language, and I appreciate it again. Thank you so much.
Thank you, Senator Tadegui. Senator Tom Fisher.
Thank you, ma'am. Thank you, Madam Chair, and thank you for all the people who are attending today. We really appreciate it. This is an extremely important piece of legislation. This is an extremely important issue for the people of Guam. I mean, to me, that's absolutely clear. I don't think anybody's going to gainsay that. And having said that, I look around the room and I ask myself, where are the contractors? These people are building subdivisions all over the island, and we are in a situation where we may not be able to remove unexploded ordnance. The Navy may not do it under certain circumstances, and we found out that we cannot. So I wonder where the usual players, like, you know, Cortec and Carlos Camacho, these people who do large developments on land, where are they? I would expect them to be weighing in on this, for the simple reason that the land that they own, that they want to develop, it may be impossible to do so when you've got a series of unexploded ordnance across the land. So I wonder where the developers are, and I also wonder where the banks are. The banks might be holding a lot of worthless paper. How are you going to dispose of mortgaged property that nobody will buy because it has bombs on it? I mean, that is just an illustration of the importance of this issue. It's laying aside the fact that people may be killed because of this ordinance. And then, if I can get a little bit partisan here, you know, we're 15 people in this legislature. This is an extraordinarily important piece of legislation, and I don't see the Democrats here. I see Chris Barnett. Thank you for being here, sir. But there are 7 more people that just can't be bothered to come down here and talk about the health of the people of Guam. Who's an independent? He is? Congratulations. But all right, so I'm just gonna let a little of that steam off. But they should be marching down here right now. So shame on them, is what I say. Admiral, when you were listening to a statement of an attorney, Mr. Chow, I was watching your reaction to what he was saying, and there was a point where I thought that you were taking exception to something he was saying. Could you expand on that?
Yes, sir. He stated there was no groundwater monitoring at the facility at Anderson, and that's not true. There is groundwater monitoring. Okay. And so that was, and that's been stated a couple of times. I'm not sure where that's coming from, but there is a groundwater monitoring there.
Okay. So that was completely inadequate, that representation, which is disappointing, because at the roundtable we also learned that a photograph that was being published on Guam to evidently illustrate the fact that the Department of Defense is being irresponsible and cranking out a lot of air pollutants and so forth and so on. Turns out that that photograph was 2 decades old. That impeaches the case, I think, that has been offered. Now, having said that, Ms. Flores, I see that you disagree, and that's fine. First of all, I wanted to commend you, and I mean that sincerely, because without community activist groups like Earth Justice, we wouldn't have, or your group, we wouldn't have the Clean Air Act. Without community activists like your group and others, we wouldn't have Clean Water Act, wouldn't have Clean Air Act, we wouldn't have the Voting Rights Act of 1965, we wouldn't have women's suffrage. It requires people to make other people uncomfortable. That's the way the system works. So I have to sincerely congratulate you for being down here for that. I won't go so far as to say I agree with everything you say, and one phrase you used that I wanted to find out what it meant. You said twice that there, I guess, is the presence on island of environmental racism. Could you explain what you mean by that?
Sure, Senator, I'm happy to do that. But before I do, I do want to respond to your comment about that image that was taken, your comment about the image that you've seen circulated around by the media and by other groups. And that, once again, is an image produced by the Department of Defense that was taken from the Library of Congress archives. And it's an explosion of an M117 Vietnam-era explosive. Now, it's really
Do you agree that that photograph is over 2 decades old?
Well, what I'm going to tell you is that an M117 bomb is listed on the Air Force's permit application for both open burn and open detonation, and actually the list of those arms has been provided to all of you.
Okay.
You can see the M117 on, I believe it's page, here, I'll find it 1 second. It's on page 18, and this is part of the, this is part of the OBOD waste analysis plan that's a part of the Air Force's permit application. And on page 18, you can see M117 bombs there. It's actually item number 62, and it's there for open detonation for a reason. One, because it's hazardous waste that they want to blow up on the open sand. And that picture is one explosion, but it's on this permit because it's going to be done at a greater frequency and greater weight than that picture actually demonstrates. And so that picture is one explosion, but it's on this permit application because it's going to be done a lot more often, a lot more frequently. So it's not inaccurate, sir. It's actually what it looks like. And an open detonation is happening right now.
Do you, ma'am, do you agree that that photograph is over 2 decades old?
I agree that that's a military-produced document of them doing open detonation here in Guam that represents what it can still look like with the same kind of explosive in the same location where they want to do it every single day. They want to do 35,000 pounds a year with this permit application. And that is taken from the application directly. I also want to say, I'm really grateful the Rear Admiral brought up Vieques, Puerto Rico, because Vieques, Puerto Rico is actually in the middle of cleanup that's going to take over a decade and cost over $800 million. Okay, this is a situation that the people of Puerto Rico will never heal from, and the government will continue to spend hundreds of millions of dollars to fix. And we are looking at a potential situation like that for Guam.
Okay, before we begin the questioning or the explanation of environmental racism, when you were talking about this particular sort of explosive and so forth, and it was evident, I think, that the Admiral does not agree with your position. Is that
I'm
correct,
sorry,
sir?
can you please repeat the question?
I'm sorry?
What? I'm sorry, can you please repeat the
when
question?
you were talking about, I guess the phenomenon of detonating this M71, I'm sorry.
M117.
M117. When you were speaking about that, you seem to be implying that, the photograph, it represents, although it may be 20 years old, it represents the conduct of the Department of Defense
It
today.
represents an explosion happening near Taragi Beach at the EOD range of of the same kind of explosive that's gonna be treated at the EOD range. And
true,
so on
is
the
that true,
same
Admiral?
list that I shared as well.
Ma'am, just hang on
sorry.
a second. I wanted
okay.
to hear from the Admiral. Is that true, what Ms. Flores just told us?
Yes, the M117 is listed on the application. The
Okay.
permit application lists a very large variety of items on there because we don't always know what we may encounter. So we leave the application as broad as we possibly can. But the M117 is no longer in service. We don't have them at Andersen Air Force Base, so we would not be exploding those at the facility at Andersen Air Force Base.
Okay.
So, and it's a pretty large explosion, and yes, the application talks about 30,000 pounds for one type and 5,000 pounds for another type per year. But we said at the round table, we're only at around 1,000 pounds of net explosive weight a year is what we're doing. Again, the application was made to be very broad and very so it could encompass anything we may encounter. We have never come close to those levels of that. So there's this thought that, because you listed on the application, you're going to be blowing this stuff up all the time. That's not the case. That's just not how the process worked for how we did the application.
Okay, well, so let me throw you a softball, sir. Just because it's on the application doesn't mean you're going to do it.
Correct.
Okay.
We also don't know what the Rear Admiral said, they also have no idea, to use his exact words, no idea how many munitions remain from World War II, from the Korean War, and from Vietnam.
I think that's
And
prob-
also
is
on
it-
this, on the
is- is it-
three-page
is that-
document that I
is that number? We heard, I think, during the roundtable that Guam endured 16 days of continuous bombardment.
right, we were carpet bombed. They carpet bombed us. That's correct.
Yeah, they carpet bombed us. I guess they were trying
Right.
to. Were
The
they, were
Department
they,
of
were they
Defense
actually were they actually trying to eject the
brought
Imperial Japanese forces from the island?
threat here, and the threat remains. It's true. The threat of these arms remain here. The threat of the arms that were brought by war and by the military remain here.
Yes.
And more threats are, coming. And on this three-page list of munitions that I've shared, all of you should have a copy now. Just to speak to also Senator Duenas' point made earlier, I just want to say we're not making this up. There are flares. There are 3 pages that were emailed. If you look at page 19, there are item 89 through 93. These are flares these are newer munitions that have PFOS and PFAS in them. So just to speak to Senator Duenas' point earlier, that these are these are not World War II. These are newer munitions that have things that stabilize them, that allow them to have larger blasts, and that have forever chemicals that don't break down in the natural environment.
Okay.
Yeah.
Those things that you were speaking about, I mean, everybody in the room wants them gone, if it's appropriate to get rid of them. The Department of Defense has testified to us that a certain species of this unexploded ordnance simply is not appropriately subject to, I guess, transportation.
Well, that's my point, is that some of this is not that kind of
Yes, ma'am.
munition.
Let me just finish the question now. Some of it is not subject to an alternative disposition, and that some of it basically has to be exploded right where it is. Do you disagree with that?
You know what, Senator? We're not going to disagree that explosives, unexploded ordnance, or even old ordnance is a problem here. We're not going to disagree with that. We're not going to disagree that it's a danger to the community. What we are going to say is that the military failed to look at safe alternatives for our community, that even in emergencies, our people deserve that, at the very least, that they failed to look at alternatives in this permit application, and in failing to do so, they broke the law.
Okay. Do you agree with that, Admiral?
No, sir, I do not. There is an ongoing look at this. It is, as I described earlier, it's much more complicated than, this exists right now, let's buy it and put it over here. It's more to it than that. So that process of doing that examination takes a long period of time.
Okay, thank you. There was, okay, I just,
But to get back to your point too, Senator, about environmental racism, right?
Yes,
that was
ma'am.
your
Yes, ma'am.
was your question.
please.
Okay, well, do you know what environmental justice is? Environmental justice. You're an attorney, and you know what environmental justice is, right? I mean, I would think that knowing about what environmental justice looks like, and seeing a community that has been forced to bear the burdens of environmental justice now for many generations. A comment was made earlier that we're only going hard for the military, but our group, Protehi Latex Save Rutidian, is actually a large collective of educators, healers, fishers, landowners, activists, artists, all kinds of people, veterans even. And we are a big community group. We have over 25,000 signatures on our petition for the firing range. We have over 5,000 signatures now for the petition on OBOD. And we do represent a large group in our community, and our attorneys are Earth Justice, so they do represent members of of this community. They're not just here to, I feel like I really just want to point that out, that we are taking a lot of our time and resources to be here because this is an important issue. We are not the military. We are not a government agency. You know, and thank you because for pointing out that it is the work of people like us, because unfortunately we can't always trust the government.
Well, I think
to
of you.
do,
I think
to
of
do
you.
what's right by
I
the
think of
people.
you in organizations like you as public servants.
So environmental
So-
racism, you know, is its own form of institutionalized racism, of institutionalized injustice, which is all a part of our colonial reality that we live here every single day, and so that's what it means. You know, if you're looking at a history where our people were forced to suffer all of these environmental injustices, whether it's Agent Orange exposure, like Senor Celestial brought up earlier, or PCBs, or nuclear radiation contamination, or the 19 military Superfund sites that have yet to be dealt with, all of the water wells that already have PFAS and PFAS contamination from the military water line that have been brought back to the government of Guam, the 500 tons of soil from a jet fuel leak that were destroyed, the thousands of munitions that will be fired over our aquifer every single year, the thousands of acres that are cleared. This fight is very different. You know, the many burials that have been desecrated. This is huge. This is massive. This is a massive amount of destruction, contamination, and desecration. This is a scar on our island. This is a massive heartbreak for our people. And to undermine all of that, to minimize the harms, is itself another layer of injustice, Senator. It's another layer of harm and injustice.
Is it your estimation that people on island, or perhaps in this room, are minimizing the issues that you're bringing?
Well, that's why we're here to support this bill, because we do feel that this bill is an important effort to minimize the harms of open detonation.
Okay, fair enough.
And to actually hold the people in this room accountable to making sure that harm is reduced.
Okay, thank you for that. I was encouraged to hear you say that you thought it was institutional in nature, racism. I don't necessarily disagree with the philosophy, because if we were going to sit here and speak about critical race theory, I think you and I'd find a lot of places where we agreed, but that's perhaps for a different forum. One of the things I wanted to ask you, though, lawyers always use this phrase, a parade of horribles. You know, people say, if in this event, A, B, and C are going to happen, and that's going to result in et cetera and so forth. And you have brought forward to our attention the idea of pollutants being in our water source and our air source and stuff like that. And I was just going to ask you, do you have any peer-reviewed stories or peer-reviewed studies, I suppose, about
Sure.
about these?
The National Academy of Sciences.
Let me finish the question, ma'am. Do you have any peer-reviewed studies about the effect of these substances on Guam? On Guam.
Oh, on Guam.
Because I'm really wondering, you know, whether or not the Department of Defense has in fact engaged in a parade of horribles that's making us sick, and I'd like to know whether or not UOG or some other source has studied it.
Well, you know, first I'd like to call your attention to two studies, one by the United States Environmental Protection Agency done in consultation with the Department of Defense, and also a second by the National Academy of Sciences, which takes a look at alternative technologies to treat hazardous waste munitions, specifically because blowing them up and lighting them on fire is extremely hazardous and extremely dangerous for the community. There are absolutely no emission controls for air whatsoever. There are also several great papers if you're looking, you know, if you want to look at other communities across the states that are impacted. There are films about it. If you want to look at folks out of Colfax, if you want to look at people in Virginia, in Radford, where open burn and open detonation take place over and over again. There are a lot of important peer-reviewed papers about all of these treatment facilities and the communities that they impact. And a lot of them happen to be communities of color and of lower economic status as well. So there's also issues of environmental racism there, or even environmental, if not racism, you know, maybe like class issues. So there are lots. Like enough for Guam specifically, you know, unfortunately, I don't believe that our university has taken a look, but you know, the Government Accountability Office also has published several papers
It would also be legitimate
about
to
several sites where this is an issue, including Vieques.
Well, it would be legitimate to extrapolate from other studies to say, well, if it's happening
Yeah, there's
there,
studies in Okinawa, there's studies in Hawaii, there's studies in Vieques. There's studies where there's been a lot of military negligence that's led to a lot of environmental violence and serious issues of illness for those communities. So there are a lot of places we could look at where there's a track record, a pattern, if you will, of underreporting, non-compliance, and harm.
Thank you, ma'am. I really do appreciate your testimony. I mean it sincerely when I think that you and your group are public servants. You're bringing issues that if we didn't talk about them, catastrophe could happen. So I thank you. I do thank you for that. And now, even more so than I guess.
Actually,
usual,
Senator, I would like to let you know that we've been informed and actually shown a lot of pictures of fishers, you know, who still fish in that area, who actually do pull out fish with tumors in them. And also in other sites of contamination here. The guili is a fish that our people still catch, and they actually eat the intestines. It's a delicacy. Yeah. And that is where you'll find, you know, some evidence of contamination. So I'm going to let you know that while there might not be a study, you know, there are people who are fishing right outside that EOD range. There are ranches, farms, schools, homes, just right outside the periphery of that base. So there are a lot of things at risk. Not to mention that without those emission controls, because there are none, that those wastes will travel far and wide, and they can deposit in other parts of the island. They can travel through the groundwater.
Are you familiar with Silent Spring?
Yes, I am.
Okay, for those who may not, Rachel Carson wrote this book.
Yes, I've read it.
Probably 59, 60, somewhere around there, and it was about the fact that we were using DDT, and DDT, the Department of Defense, they needed it because of the prevalence of malaria, especially in the tropics, especially during World War II, and they came up with DDT, and it just worked like gangbusters. Took care of the mosquitoes, and it also took care of a lot of babies. We wised up and we said no more DDT, which just proves your point. These things do get into the environment. They do get into the food table. They get into DDT. I mean, we almost lost all the bald eagles because of the eggshells.
Sir, some of these chemicals, they build up in concentration over time, okay? They don't break down in the natural environment. They also build up in concentration in our bodies.
Yeah.
Okay, so we're not just talking about a one-time exposure, we're talking about a lifetime of exposure that we have to really consider, and that this is not going to just impact every single person in this room. It's going to impact our children, our grandchildren, and our great-grandchildren. And so all of these decisions that are, you know, that's really why I just have to get back to this bill. That's why, you know, please, we ask you respectfully, senators, to move on this expeditiously.
Yes, and believe me, we join you in that. We do need to move on it expeditiously. And I've just got, I guess, just one more question for you, or not for you, ma'am, but Admiral, can I ask your attorney a question?
Absolutely, sir.
The gentleman's behind you. Commander, in the Admiral's testimony, he says, first, Bill 35-37 requires permitting for emergency response to fired munitions. Under federal law, emergency response is outside of the environmental hazardous waste permitting authority. My question to you is there a supremacy clause issue here? May Guam legislate in this, in your opinion, can Guam legislate in this area?
Good afternoon, Senators. My name is Lieutenant Commander Joe Horton, JAG Corps, U.S. Navy, and I'm the Fourth Judge Advocate for Joint Region Marianas. To answer your question, Senator, there is no supremacy issue here, as the EPA has authorized the Guam Hazardous Waste Program as allowed under RCRA, the Resource Conservation Recovery Act. And so under the consistency requirements that are contained in the federal regulations promulgated under RCRA, a state or territory that has an EPA-approved program can pass legislation and regulations that are as strict or even stricter than the protections provided under federal regulation.
Can we prescribe regulations which are less strict?
So the answer there is you can. However, that will probably fail a consistency review from EPA Region 9, and they will then notify the state regulating agency as well as the legislatures that that particular law is not as consistent as the federal program. They will try to rectify that, and if it is not rectified, Region 9 and US EPA would have the ability to rescind the delegated authority given to the state that has passed legislation or regulations that are not as strict as the federal program.
Okay, so depending on our actions, we could actually lose the ability to regulate our own environment?
Yes. And the other thing with consistency reviews is that if you passed a legislation like the previous bill that is perhaps stricter, but so strict it actually increases the risk of contamination to the human environment or harm to human life and the human environment, then that too could result in a state or territory having their primacy removed by EPA. Because although on the face of the law it seems stricter, it actually is counterproductive because it creates more risks to the environment and human life.
Okay, all right. Thank you very much, and thank you, ma'am. I don't have any further questions.
Thank you, Attorney. I'm sorry, thank you, Senator Fisher. Senator Barnett?
Thank you, Madam Chair. I just had, first I'd like to start, thank you guys for coming out to testify. And I also think it's interesting that we would, out of one side of our mouth, praise activist groups like PROHIBITION, but then not heed the warnings. I know one of my colleagues up here had brought up a point about us going after the military, so to speak, but I think that past instances and the history of actions by the U.S. military on Guamanian soil warrants this type of scrutiny. I know I'm not the only one here that understands that there is a history of deception, misinformation, and not, to cast you guys in that light, but it is what it is, right? I mean, my grandmother sold her land to the United States military for 2 cents an acre in Radio Barrigada, so I think that the history really warrants this type of scrutiny. But I just want to start with Walter. Can you explain a little bit more about exactly what losing primacy means?
So currently, Guam EPA has the ability, as stated, to enforce RCRA regulations over hazardous waste on Guam and any of the stakeholders or regulated community. If we lose primacy, which the initial bill, the verbiage on the existing law, US EPA Region 9 may determine, but they determined that based on the verbiage, they could take the primacy away, which is why the urgency to amend the current law. And a lot of the amendments that we've discussed, and again, not knowing what the full draft legislation would be, would determine if we maintain primacy. If we lose primacy, what will happen is our agency can still manage and do hazardous waste, but the enforcement part, which includes fines and fees, would be all reverted back to the federal government, US EPA Region 9, and we wouldn't be able to do that.
I've covered the environment as when I was in the media, and I just want to ask what the difference is between the penalties and fines administered by Guam EPA when compared to the penalties and fines administered by US EPA.
I don't have a table in front of me.
Just maybe a general description?
It generally is pretty similar to each other, but one goes, again, if it's under the coffers or under the administration of the federal government, it goes to the federal congressional budget, where ours goes into our special funds. And if we don't have the special funds, which we do for our hazardous waste, then it would go to the general fund. So it's more a matter of administering who polices it, so to speak, and where the funding would go to at that point.
You know the case that Muñeca is referring to with there was a pipeline jet fuel leak that I think ran from Agani Heights all the way up to Anderson, and Maybe refresh my memory, was it 500 tons of soil that had to be removed? What do you recall offhand, what was the fine that was issued in that case?
So at the time, we issued the highest available fine to the contractor. We also engaged with the military because it was a military pipeline that they need to be watching their contractors and whatnot. So we gave the most severe fine as possible, yes.
Would you say that that US EPA is maybe better equipped to enforce environmental infractions, compared to Guam EPA?
I would dispute that, sir, Senator. I think our team does an ample job. We are working to increase our capability and with more people being out in the general public looking, and we are working on that. We actually have funding for that, and the hardest thing now is getting people that are fit the position description to hire. But we are currently there. The laws are in the books that allow us to provide the proper oversight. We do probably need to increase some of our fees and fines so that we become more up to date and can maintain our level of capability of doing enforcement on the island. But yeah, I would not advise or say that US EPA they have more people, but they also have a larger region to oversee than we do. Thank you.
Would you compare losing primacy to receivership?
Receivership is when part of the regulated community fails to meet the requirements of the local law as well as the federal law, and so that's where they get enforced by the court to do meet certain standards, and they're somewhat different because one is taking away the ability for the regulated agency, Guam EPA, to provide oversight and determine, again, as stated, we can even make things more stringent than the federal government, where the federal government, this is it. When we have primacy, if we determine that something needs to be added for Guam's site-specific conditions, the feds don't do that. They stick with their regulations that are nationwide. Not all of our regulations or the programs that we have primacy for are more stringent, but we do have a few that are more stringent. And so again, it gives us the ability to regulate and oversight locally and not just be on a national scale.
Thank you. Admiral, if you could explain, because I know you had said that removing discovered ordnance, I believe off base, was part of the military's mutual aid agreement with the government of Guam. Could you provide more detail on what exactly that agreement is and how binding it is for you guys?
Certainly. So we have a mutual aid agreement with the government of Guam that basically, I'll try to boil it down the best I can, but basically says that the U.S. military will do the explosive ordnance disposal or bomb squad capabilities for the government of Guam. This is, and again, we have mutual aid agreements across a number of different areas. That's why we have our Department of Defense ambulances and fire services either respond to or supplement Guam Fire and Guam Police. But in this one particular area, there is no capability whatsoever for the government of Guam to handle explosive ordnance disposal. So we, in effect, then, in that agreement, are the bomb squad for Guam.
Right. And so 8 days or 7 days, can you kind of walk us through again the scenario that could occur?
Yes, sir.
In a week's time?
Yes, sir.
Let's say you were to get a call that run through the process. We discovered a bomb at a construction site outside of the fence.
Yes, sir. So when this first came up, and when I had this discussion with the governor in earlier this year, I had thought, okay, well, we can go and we can have our folks look, and if they can determine it's World War II, we'll take care of it and this sort of thing. And then, because this is such a complicated issue, when we kicked it to D.C. and to the lawyers, they said, no, Admiral, you can't even do that much. I said, okay, what can we do? And so we basically are at the point now, because of as the law is currently written, and even as the current bill that amends it, if we don't change that as well, we're in a position where our folks can go out, they can look and they say, yep, that's not ordinance, that's a pipe, that's some other piece of metal or whatever, so it's just scrap, and then they leave. If they say, no, that's ordinance, we're in a position now where we can't do anything about it. And that really concerns me. I mean, from ethically, we want to take care of it. Ethically, I can speak, Lieutenant Moyer is like, that's a bomb, that's my job, that's what I've been trained to do. I need to take care of this to secure the people and the property here in Guam. The problem is legally, because of the language, the confusion of language, our Department of Defense lawyers have said, no, you have to stop. You can't do that. And so that's the bind that we're in, and that's why the words matter so much. And as I said earlier, some attorneys say, well, yeah, obviously you can do those sort of things, but the attorneys that govern what we do and give me the authorities to say, yes, you can or cannot do that, they say, no, you can't do this sort of thing. So that's why it's so important that we work together to get that language correct.
So if you got the call that there was unexploded ordnance again at a construction site off the base, what would the message be that you would relay to the local officials?
Cordon off the area, and that's it.
Is the process going to be the same in 7 days for unexploded ordnance that's discovered inside the fence line on military property?
Same thing. I can't tell my people to break the law. So we cordon off the area, and then that's it. And we're in a holding pattern until such time as either the ordinance goes off on its own, which I would hope that wouldn't happen, but it can happen, or we get some sort of regulation that says that we can do this, and we get some clarity in the law that says, okay, you're not breaking the law. You're not issuing an illegal order, Admiral, to tell the EOD team to go out there and dispose of this unexploded ordnance.
Can you provide more detail? Because I wasn't able to attend the last hearing, but I know that there was some testimony that indicated that World War II ordnance wasn't the only ordnance that we might discover, that there also might be the potential to discover Korean era and Vietnam era bombs?
Yes, sir. So first of all, our teams have discovered World War I era ordnance here because there was some here. The vast majority...
Can you provide the circumstances under which that ordnance was found?
I'll turn, Lieutenant Moyer, do you know about the World War I ordinance?
Are you asking about this specific history of World War I in Guam to me?
No, I mean just because we didn't, we weren't involved in World War I. So
yeah, I believe if I could remember correctly, there were small projectile objects found in. I'm trying to think where. I guess that would be PD. That's personal. There's been more found outside of my time on the island, but yeah.
Were these ordnance that were were they possessed by a person, or were they just discovered?
They were discovered on hiking trails.
Okay, sir. And the vast majority is World War II, and we have no idea of how much ordnance the Imperial Japanese Army brought here. And then again, the island was subject to about 16 days of shelling from both surface vessels and aircraft in order to dislodge the Imperial Japanese Army. Then once ashore, the Marines and soldiers that were here, they engaged in a battle for quite some time, for about a month long of intense fighting, and then still minor fighting that happened after that. So that's quite a bit of time that happened. I would say, and I can't say for sure that it happened in World War II, but it likely did. World War II, Korea era, and Vietnam era ordnance. So there was, at the times, sometimes the ordinance, we don't deal with things today like we did with back then, right? RCRA was passed in 1967 and CERCLA was passed in 1980, right? So things have changed over time. But back then, things were done differently. And sometimes, okay, we don't need this ordinance anymore, we think it's safe, and they just put it in a pile and they buried it up. And that's what we've encountered sometimes on some of the construction sites. We uncover some ordnance like, wow, that's not World War II, that's Korea era. And potentially the same with Vietnam era. It's unfortunate, but that's kind of the state that we're in as far as those other ordnance that could be found here.
So you mean to say that the United States military on Guam buried ordnance and now doesn't want to take care of it?
No, sir. It's not that we don't want to take care of it. It is that when we find it, when we know about it, we take care of it. The other thing I will say is the way we take care of ordnance for, let's say, an old range complex, we have a very good idea of how much ordnance was expended at that range, because you take records, okay, we went to the range that day and this many rounds were expended and that whatnot. But on Guam itself, on the entire island, we don't know those numbers. And we're not sure of where things were done, where it was put. But when they're found, we do take care of them, because right now we're authorized to, because the law allows us to.
Who do you think is ultimately responsible for disposing of munitions or bombs or any of that type of weaponry that was disposed of illegally by the United States military?
Well, the United States military does take care of it today and will continue to as long as the law allows us to.
I'd also like to ask, sir,
I want to clarify. At
Yes.
that time, that was not illegally disposed of. If we did that today, yes, illegal.
Right.
At that time, it was not.
Yeah, and that's just going back to my point about having to hold you guys to a little bit higher level of scrutiny, is because a private contractor or a private business or even our local government doesn't have the ability, the propensity to pollute the environment in the way that, because of the nature of the things that you guys handle on a daily basis, in a way that you guys can. And so I think the scrutiny for the military, especially given the hindrances that our political status allows us, I think we have to hold you guys to a higher standard. So I hope you can understand. I think that the chair has expressed her intent to deal with these safety issues that you're bringing up, and I feel like we're talking about repealing a section of law, but I really feel like this bill that we're hearing now is the best option, because we can't repeal a law in 7 days. If Senator Duenas is going to introduce a bill, I don't even know if we could hear that in 7 days. We're already at a public hearing for this bill, so if you look at the options, I think that this measure is the furthest ahead. And I think that the chair has indicated her intent and willingness to address a lot of these concerns that you have. But could I ask, with unexploded ordnance, would alternative methods ever be a viable option for disposing of, World War II or any ordnance that was legally buried by the U.S. military on our soil?
Sir, to address your previous comments, I just want to make clear that the Military Munitions Act was passed in 1997. We've had plenty of time to adopt that, and that would have actually taken care of a lot of the issues we're talking about today. But that was thought through, and it had a process to get to where we are. We're kind of, right now pushing something through very quickly, and that I'm just concerned the complicated issues that deal with this. To your other point on the local businesses, absolutely, hold the military to a high standard. But when we do things, do a complete study. There are other things, there are other pollutants out there that are very, that concern me quite a bit, and that should concern everybody. And so when we study these things, we should study across the board. Don't just study ordnance, study all of the things that could be pollutants, and let's together get after all of those things. To your point on the unexploded ordnance and will there ever be technology, there may be at some point in the future. The problem that we have specifically, the older the ordnance becomes, the more unstable it becomes because of the breakdown. As I quoted the National Academy of Sciences report on this, that's where it becomes a little bit different of a problem that we get with here. Should we be looking for other ways? Absolutely. In fact, that's what's going on right now, is looking for how we can do this. But we're at a point right now where it's not as if we can bring one thing to the island and it will take care of everything. We're trying to figure out how we would do that. But if we were able to adhere to and pass the MMR, there'd be a lot less to deal with. It would really only be the unexploded ordnance that we would have to worry about here in Guam.
In your testimony, and I'm going to quote it, because of the pending February 27 deadline, we believe the best way to proceed is to repeal the open detonation portion of Public Law 36-139 as an interim step, then continue to work with all stakeholders to determine what legislative or administrative changes are needed in concert with US EPA's existing regulations and future rulemaking. Could I ask what types of open detonation would be allowed if the legislature were to heed your recommendation and repeal the open detonation portion of Public Law 36-139?
Certainly. Currently, we would continue our permitted operations at the facility at Anderson and our emergency response operations. And then, working together, come up with a agreeable language by all parties, a timeline agreeable by all parties to try to get down to a point where we're really only addressing the unexploded ordnance, which that's the part that's the most difficult to deal with from our perspective.
So if we were to repeal the open detonation portion of Public Law 36-139, could you give me an accurate idea of how many different ordnances, bombs, munitions outside of World War II unexploded ordnance would you be open detonating?
Sure, I don't know. I can look at the past records, but as testified the other day in the round table, I want to say that it was about 400 pounds that were done last year. So it was in nowhere near the upper limits of the permit. But again, that's something that we can work to reduce over time. If we work together on the language, if we do things like adopt the MMR, there are ways to get that down to potentially get it all the way down to zero. So we're really only dealing with the unexploded ordnance.
So is it your estimation that if we were to repeal the open detonation portion of Public Law 36-139, that outside of the ban on open burning, that we would kind of be like right back where we started from before this measure was introduced?
To some degree, yes. But I think that this has brought forth and highlighted this issue. I believe, I will say, just in my conversations with the folks in the Pentagon and higher headquarters, this has kind of given a renewed energy to looking at this and where we can go in the future. So I would say that the part there where the collaboration of the stakeholders working together on this, I think that that's going to go much, much better, and we'll probably get to solutions, probably the right solutions in a better time frame than before this was originally introduced.
So it's safe to say that if we were to repeal the OD portion of Public Law 36-139, that it would be a reasonable assumption to assume that you would be open detonating all of the things listed on your application?
No, sir, not all of the things under there. Again, the application is made with the widest breadth. It's just a very small amount.
You cast a wide swath, but I think that it's reasonable for us to, I mean, if I, put in an application to work somewhere, I mean, the assumption is that I'm putting in that application so that I could work there. So when I see something in black and white that says we want to be able to do all those things, although you're saying, oh, we might not do all those things, I'm saying that you could if it's on your application, if it's approved.
I'm also saying that the EPA can limit us that, the Guam EPA can. So because they have primacy on that and they control that permit, then they have the ability to, as Walter said, hey, we'll take out the open burn. Boom, it's gone. They already have the ability to do that.
How many, cause I know that we can't nail down how much World War II unexploded ordnance is left on Guam. I know that it's, common knowledge where carpet bombs, 16 days, with both Japanese and American bombs and all that. But how many calls does EOD get in a year?
We typically average about one a week. Let me clarify. Okay. We typically average one a week for outside the base response.
And then when you respond to those calls, how many of those calls involve open detonation? And how many of them are like, oh, that's good?
So all of them eventually result in open detonation. Some of them are detonate in place. That is, the ordnance that's found is so unstable that touching it or trying to move it creates a great hazard. And so the teams have to very, very carefully do those, and they have to get permission from the landowner to be able to do that, and then they will blow it in place. For the other items, if they are determined and deemed that they are safe enough to transport, then they will be transported to a storage area where they are only allowed about 30 days time period to be stored before then they are put together in mass and then detonated together. Because as I stated earlier, the longer you let that sit, exposed to the oxygen, and it becomes even more unstable. So that's why we give ourselves a very finite timeline to detonate those things. But we do that in a controlled manner away from everything else at a facility, unlike the ones where we have to do what we call a blow-in-place or detonate-in-place operation.
You know, we're talking about implementing alternative methods, right? And it's a pretty easy Google, right? You know, alternative methods. There's a whole bunch of stuff that comes up, and Lord knows that the Department of Defense definitely has the means, right, to at least acquire these technologies. But I haven't really heard a lot of detail about how long. I know that there was a 1 to 3 year period that you mentioned, but in a perfect world, how long would it take for the Department of Defense to implement alternative methods on island?
Sir, I couldn't quite answer that now. I'd have to turn to some experts that would know how long that would take. But I'm also very concerned about it's not just, okay, we buy the technology and we put it here. There are the secondary waste streams that have to be dealt with, and how do we ensure that because what we don't want to do is, okay, we have an alternative method and we put the stuff in it and magically it can take care of every kind of ordinance we can, but we know that's not the case today. But let's just say, for argument's sake, you can. In the end of the day, then, that thing is creating, gallons and gallons and gallons of hazardous waste that we, store in 55-gallon drums or whatever. Now, how do we take care of that? So you have to do the entire life cycle to figure out how you're going to do these. And when we talk about these plants back in the United States that are at an arsenal that deal with the life cycle, they've got all of that built in. It's not just the alternative technology to take care of the ordinance at the end of its life cycle. It's also how do you handle the secondary waste streams that come off of that. That becomes a lot more difficult here. So the timeline, I think, is pretty extensive, because there's a whole bunch of things that have to be put in place to be able to do this properly.
So you mentioned the 5 points in your testimony that you would like to see, I think, amended on this measure. So if we were to put those 5 points in, would Joint Region Marianas then support this bill?
I've laid out those 5 points because I think those are the 5 tenets that we need to have in there. My concern is not that those points get put in. My concern that there is time enough for the attorneys on all sides of this to agree that the language that we've proposed, that it's good for everyone. That's my concern, is the time frame. If those 5 points are adopted as we believe that they should be, then we're okay. But you heard it earlier, you have 2 different sets of attorneys that look at the same law and they read it differently. So we have to be sure on what we're saying, because I don't want to adopt something and then, because of how it was specifically written elsewhere, then we come back and say, well, no, wait, that's not what we meant, and we end up in the same situation we're in now.
Yeah, I mean, I understand that we all have to be on the same page. My concern is, whose book is it, really, right?
Understood.
Again, I would just, before I close, I'd just again commend our chair. I think we're really treading in unfamiliar territory here, but I like it. I like that we have a legislature that is trying to hold the federal government accountable, right? And I like that we're engaged in this conversation. And I also like that we have federal people sitting in front of us telling us that a local law is actually going to bind them to actions that, the previous legislature agreed were good for the people of Guam. And I know we're not going to get anything done in 7 days, that's for sure. So I would just ask on behalf of the people if you would continue removing unexploded ordnance in good faith. We're a patriotic place. We, per capita, we've got a high number of people serving in the military. We've surrendered 1/3 of our island to the military. And I think it would be a good faith measure, especially, considering that you just testified on the record that we've buried munitions legally then, maybe in need of attention now. I mean, I would like to see the military move forward with the cleanup and removal of all those munitions, regardless of what a local law says.
Sir, we've cleaned up the sites where we know they are. We don't know where all of those sites are, and that's what happens when construction happens and we come across new stuff. And sir, I would, again, ethically, I want to do that, but if I legally can't, I cannot order my people to do I cannot give them an illegal order. That's something I cannot do, and that's where I'm really bound right now on where we are. And you know, there's been some talk of, well, just ignore it and do it anyway. I can't do that. So that's why I'm really very passionate about this. That we've got to get this fixed, and we don't have much time.
But you do understand that, I mean, 7 days is, I think, a pretty impossible timeline.
Sir, I didn't set that timeline. I wish we would have had this conversation a year ago or 6 months ago.
Right.
But we're in a jam now, so we have to do what we can do.
We sure are. And so if we put those 5 points in, if we address your concerns, who's to say that you're not going to come back to the table with 5 more concerns?
Sir, that's why I think that we need to take the time to do this right and have a full legal and technical analysis. You put that information in, and then we have the lawyers on both sides come to an agreement. Yes, this does meet it. We don't have any other issues with it. But that didn't happen. And so we're in a situation where we have very little time to do something to ensure that we can continue to provide response for the community of Guam.
Thank you, Admiral. And thank you, Madam Chair. I know this has been a very trying process for you, but again, I commend your courage, really, in introducing not just the first measure, but this second one. And I sometimes wonder if is there more than one version of this bill out here? Because based on the testimony that we're hearing, I feel like some people might have another copy that maybe we didn't get. Sarcasm. That's sarcasm. Thank you, Madam Chair.
Okay, thank you, Senator Barnett. I want to thank everyone who's come out here today, who participated in this hearing. You know, all of this engagement in this process is essential to creating more equitable, environmentally conscious legislation that centers the health of our people of Guam and our genuine security. This discussion comes at a time of heightened awareness and over the concern of the health impacts of OBOD among military veterans and the broader community of the United States. Nationwide, the variance to prohibit open burning of hazardous waste and open detonation was established at a time when there were no safe alternatives to the treatment of waste explosive by OBOD. However, with newer findings, the National Academies of Science, Engineering, and Medicine, EPA, is in the process of revising its regulations to promote the broader use of these alternatives. Public Law 36-139, which received overwhelming support in the last term, was a tremendous step forward for the people of Guam and puts us at the forefront of this national discussion. And now with Bill 35-37, we have the opportunity to continue this momentum by refining and strengthening Guam law with regard to the will, health, and safety of the people of Guam, and creating a culture of responsibility that everyone who calls Guam home can live by. I want to highlight this culture of responsibility for a moment, and what this means for us who are fortunate to call Guam home. For the people of Guam, Mr. Celestial's testimony shows we are the ones who will have to live with the consequences of a poor environmental policy. Our children and our children's children will be the ones to inherit a legacy of sickness, and if we turn a blind eye to the systematic, large-scale, and unchecked open detonation. When we're talking about a culture of responsibility, we are talking about Inaf Malik and the interconnectedness of everyone and everything on Guam. Whether you live inside the fence or not, environmental contamination affects us all. It is important to remember that the PACT Act and the movement to recognize the staggering impact of exposure to chemicals from military waste and training was spearheaded by military veterans and their families who were impacted by these activities. The amendments proposed in Bill 35-37 are meant to ensure the health and safety of all people living on our island, including those that are just visiting or stationed here. We must all understand that whatever happens here, the people of Guam will have to live with it. And we must make sure that everyone is conscious of that and that everyone understands that. Again, I'm encouraged by the fact the Rear Admiral is acknowledging there's a potential to amend the bill so that a full repeal no longer makes sense given the number of amendments already provided, and which can continue to be made to Bill 35-37. Although it may be the case that open detonation may continue to be necessary for some munitions, by and large, the data and the redeveloping of federal guidelines shows positively the military can and should be using safer and cleaner alternative technologies when it is absolutely safe to do so, as determined by Guam EPA and US EPA. And collectively, we can come to the same table to create a policy that reflects that. I would also like to let you know that we will expedite this bill in light of the urgency of the matter. And we will be looking forward to, we'll be in close contact with you as far as changes. So it's Duas Masi for your time. Thank you. At this time, the committee now, seeing that there are no other testimonies being provided, we will still accept written testimonies as soon as you can get them to the committee. So if you can send them to us by 4 p.m., let's say tomorrow, February 21st, please address testimony to Senator Sabina Flores Perez, Chairperson of the Committee on Environment, Revenue and Taxation, Labor, Procurement, Statistics, Research, and Planning, or it can be dropped off here at the Guam Legislature Building or emailed to office@senatorperez.org. Seeing that there are no further comments or questions or testimonies provided, the Committee on Environment, Revenue and Taxation, Labor, Procurement, Statistics, Research, and Planning will now adjourn this public hearing. The time is now 12:46 p.m. Duas Masi.